Yes.
Lordship, item number 40, Lordship. It may be taken up today, Lordship, upgraded according to your Lordship, convenience today, Lordship.
14.
Pending for a long time, Lordship. Lordship has fixed the date, but he again has come down the list. Item number 40.
Which one? Item 1.
Item 40, Lordship. 2205 of 2020.
Is the
Lordship.
matter about?
Lordship, pension and rear salary, Lordship. At 2, Lordship. Awesome.
For the response, for the petition.
My pleasure, Lordship. Lordship, with concern of the respondent, Dibuga University Authorities matter, I beg to mention item number 25 of the daily list matter. Here they have filed a copy of the affidavit in opposition matter. I pray for some time to file a reply matter.
You are the respondent.
I appear for the petition matter.
Okay. The learned counsel seeks for an adjournment for 3 weeks for the purpose of filing their reply. That the matter will be listed after the summer vacations.
Highly obliged.
Oh, this matter, those matter. You have that number, that of 2016? List this matter along with that I think of 2016 on 7th of August.
May I please? I beg to mention, my lord, one item. It was listed on Friday, my lord, but as your lordship bench was not there, so it was not taken. But it was fixed on that day, my lord. It was connected to matter, my lord, is a secondary issue, my lord, for we filed a miscase for modification of some.
Oh, that one.
Yes, sir.
We'll have it done. Today is what? 28?
Obliged.
Mr. Purkasta, did the other side get the opportunity of looking into those?
Yeah, I have. They have.
Have they filed the
Yeah.
affidavit?
They have not filed, but they have received our.
Mr. Sharma, this matter pertains to the stipendiary teacher. Now, this was a review. It's a review.
Not miscase. Miscase actually.
A miscase is in the form of a review. That matter was listed in a drop teacher, excess teacher, and should have been in fact a case of stipendiary teacher.
Yes.
I had asked the government out there to look into that aspect of the matter as to whether it is true or not. So kindly be ready with this matter. What is the item number? The repetition number. Yes. Okay. The request of the learned counsel for the respondent matters then adjourned to be listed after summer vacations.
May I please, your lordship? I beg to mention item number 41. Kindly adjourn the matter for today. Senior is out of station.
Okay. At the request of the learned counsel for the petitioner, matters stands adjourned for 4 weeks.
Obliged.
Yes. Okay, at the request of the learned counsel for the soil conservation department, matters stand adjourned for 4 weeks.
Lordship, date may be fixed. I am for petitioner.
The matter stands adjourned for 4 weeks to be listed on 14th of August.
May I please your lordship, I beg to mention item number 32, lordship. To which
Yes.
time may be allowed to file our affidavit in reply, lordship.
The request of the learned counsel for the petitioner, matter stands adjourned for 4 weeks, enabling them to file their affidavit in reply.
Daily list item number 1 for motion.
Madam, your mic is not working properly. Yeah, tell me.
This one is matter is not taken of area salary, my lord.
Hmm.
As per instruction of Executive Engineer Mongoldo Division, correspondence has been made to the higher authority for payment of the area salary, my lord.
How much time?
I will be allowed further time to obtain instructions as to the present positions of this matter, my lord.
Why this person did not avail the remedy at that point of time, ask for the area salary there? None appears on behalf of the petitioner. They also. Ms. D. Neo, the learned standing counsel for the irrigation department, seeks for an accommodation to obtain the necessary instructions in terms with the order dated 9/6/2023. Notice has not been issued.
Yes, your lordship.
Who is this lawyer? He's not appearing twice also. Oh. His name. A new matter, he is not responsible. Alaga ito na. None appears on behalf of the petitioner on call. Ms. Dino, the learned standing counsel, appears on behalf of the irrigation department. This is a recent petition filed in the year 2000, filed on 2nd of June 2023. It surprises this court that the petitioner has not been represented. The petitioner was not represented on 9/6/2023 when the matter was taken up, as well as also today. This court fixes this matter on 19th of July. It is made clear that if the petitioner is not represented on the said date, this court would have no other option but to dismiss the petition for non-prosecution.
I know 2.
May I please, your lordship? Lordship, the petition is a covered, Mr. Lordship, covered judgment, my lord. Lordship, kindly see the covered judgment, page 75, lordship. Judgment passed by lordship.
Page 79 of the
7.
disposed of. That increment thing.
Lordship.
Lordship, the secondary matter, lordship, perhaps the
Huh?
matter pertains to perhaps the secondary education department.
Secondary education.
Lordship.
You are there.
So file this is not there at the moment.
Not necessary. This is a matter, but then this increment, BA thing.
Beheading.
Dispose of Keton Nam to the. This is Baksa is there. So means which are the respondents here? PN Sharma appears for respondent number 1, 2, and who appears for BTC? No,
RTM,
get hold of a BTC council.
RTM.
Name. Otherwise, name is not shown for BTC in the cause.
Get hold of a BTC council.
Yes, Borang,
Understood, but if he is not there, how can I say it to be disposed of? We'll take it up after some time. Get hold of a BTC or Mr. B. Chaudhary, whoever it is.
Number 3.
May I please?
Yes.
In this case, my lord, what happened? This is second round of litigation. After the first round of litigation, the ONG LIC has paid the my lord 1/3 of the annuity amount, my lord, and thereafter they had issued the impugn letter, my lord, page number 33.
30?
33.
What is this?
This is the letter, my lord. This is to inform you that in reference to the order of Honorable Guwahati High Court, order dated such and such, we have paid commutation amount of rupees 18 lakhs 2,379 dated 23/2023 in the said annuity. Now, after commutation, your purchase price is revised from 54 lakhs something to rupees 36 lakhs and all, and installment amount will be 20,461 per month instead of 30,688 per month with effect from 1/4/2023. In this regard, we have received a letter from our competent authority, Central Office, Mumbai, to be recovered the difference of annuity installment rupees 7,26,117 at the rate rupees 10,227 per month from 1/4/2017 to 1/3/2023 to enable us to release the revised annuity installment to you. This, my lord, they have kept our amount LIC 54 lakhs from 1/4/2017 to my lord 1/3/2023, and against that they have paid 30,000 per month pension. Now, after withdrawal of 1/3 amount of 18 lakhs, the amount has reduced to 36 lakhs. And amount pension amount is fixed at 20,000. Now what they are asking, my lord, for the period what they retained our money and they paid us against the investment. Now they want to take it back. That is not permissible. They have retained our money at 54 lakhs for that period, and against that amount they have paid us 30,000, and now it is the 1/3 is withdrawn. Now 2/3 against 2/3 20,000 per month, that is there. But now why without any reason, my lord, they are asking, they are trying to fix the amount 2/3 from the date 1/4/2017, meaning thereby they want to they have utilized our money, they have earned the from that amount, they want to take it back now. That is not permissible.
So you say that is without reasons.
Yes, sir.
We have to know the reasons. Heard Mr. E. Purkaster, the learned counsel appearing. Who appeared?
I for respondent number 1, Union of India.
The people Purkaster, the learned counsel for the petitioner, Mr. S.S. Roy, appears on behalf of the respondent number 1. Issue notice making it returnable on 9th of August 2023. As Mr. S.S. Roy appears on behalf of the respondent number 1, extra copy of the writ petition be served upon him by 30/6/2023. As regards the other respondents, that is the respondent number 2 to 6, steps be taken by way of registered as well as usual by 30/6/2023. The petitioner herein is aggrieved by the communication dated 13/4/2023, by which an amount of rupees 7,26,117 have been sought to be recovered by way of a monthly installment of at rupees 10227. No.
At a time, my lord, not installment, my lord.
Oh, okay.
They're asking for
I
7 lakh
have
20.
challenged the order dated, the communication dated 13/4/2023, whereby there was a direction to the petitioner to deposit the amount of rupees 7,26,117. The respondents are directed to file their affidavits on or before the next returnable date as to why the impugned communication dated 13/4/2023 has been issued.
But in the interim, my lord, I may be given the
What?
pension, my lord.
You
They
are
have
getting
stopped my
pension.
pension, my lord.
They've stopped your pension.
Yes.
But if I allow the pension out here, wouldn't that be allowing it without knowing? You also want to know the reasons. That is why I asked them to file the affidavit. Wouldn't that be a giving up? Means allowing the petition at the present. Next.
I know 4.
You want to take steps by way of the stick upon the main one, not on the others. Because who?
LIC, they have got the panel advocate, my lord. I should start I may be allowed to start through him, my lord. Mr. Mondal is there, my lord. My lord.
No. You the petitioner is further given the liberty to effect service of notice through dusty upon where you can talk. This is done by out here, some officer out here.
Yes, Jorhat.
No, no.
The local office is Jorhat, my lord.
No, you have not made it, na. Local office is not a party. No. It can't be done.
There are the, my lord.
No, it can't be. We have to wait for some. Yes.
May I please illustrate? This petition has been filed paying for subsistence allowance. The petition has been suspended on 18/11/2022. He is still under suspension. 18/11/2022. It's more than 6 months. He has not been paid such a allowance. Annexure 4, page number 24 may be filled.
Annexure 4, page number
24. Well, putting me under suspension, it was provided on the last line. The officer shall be entitled to subsistence allowance as per rules.
Mr.
Till
Datta.
date,
My lord, I have taken instruction, my lord.
Understood, but you have to pay the
Yes.
subsistence.
He is entitled, my lord.
The-
current yearship I may pay.
And
Mr.
one more, my lord. We are already processing, my lord, for reinstatement also, my lord.
That is okay, but you want to do
He is
his-
entitled for.
he's entitled to his subsistence.
Because of some technicalities, my lord, they have informed me. He may be directed to present before the authority, my lord, for once, my lord. Some document is required, my lord, from him also, my lord, to submit the proposal for AG, my lord. That is my instruction, my lord.
53-2.
Maybe.
Yes.
You have not given that. That you are not
Maybe, my
working.
lord. He may be directed to appear. Thereafter, we will forward the proposal.
Mr.
R.A. Chaudhary.
R.A. Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. S. Datta appears on behalf of the respondent numbers.
1 and 2, my lord.
Respondent number 1 and 2. And Mr. Who is the accountant general? None. Anybody seen the site in the court today? Mr. R. Talukdar, A. Hassan, anybody? Have you seen anybody today? You have seen him? Mr. R. Talukdar appears on behalf of the respondent number 3. Issue notice making it returnable by, we'll have it on 19th of July.
My lord.
No, We'll have it on 26th of July.
My lord.
Better off giving you 1 month time to clear that. Issue notice making it returnable on 26th of July. As Dr. duly appears on behalf of the respondent number 1 and 2, extra copies of the writ petition be served upon him by 30/6/2023. No, 1 and 2. As regards the respondent, as the respondents are duly represented by the respective councils, extra copies of the writ petition be served upon them by 30/6/2023. The case of the petitioner herein is that the petitioner was put under suspension on 18/11/2022, pending withdrawal of disciplinary proceedings. Pursuant thereto, it reveals that the disciplinary proceedings have been initiated by serving the petitioner the memorandum of charges. The grievance of the petitioner is that the petitioner has not been paid his subsistence allowance during the pursuant to the order dated 18/11/2022. The learned counsel appearing on behalf of the petitioner has drawn the attention of this court to FR 22 and Rule 22 of the Assam Service Pension Rules. Oh, no. Subsistence allowance will be under 53. Under FR 53 of the FR and SR as applicable to the state of Assam, and submitted that he is entitled to the subsistence allowance during the pendency of the instant during pursuant to his suspension. Taking into account the above, this court is of the opinion that the petitioner is required to be paid his subsistence allowance if not paid till today. Mr. Elder, the learned counsel appearing on behalf of the Panchayat and Rural Development Department has submitted that the subsistence allowance, that the authorities are not in a position to pay the subsistence allowance in view of a particular documents having not been submitted by the petitioner. Taking into account the above, this court therefore directs the petitioner to approach the authorities concerned and submit the necessary documents which shall, upon submission of the said necessary documents, the respondent authorities are directed to pay the subsistence allowance, the area subsistence allowance, as well as the subsistence allowance till the pendency of the, till he is reinstated or subject to the outcome of, or the outcome of the departmental proceedings. Now, till he is kept under suspension. Till he is kept under suspension. Dispose of. Mr. Dutta, you can dispose of.
Lordship, returnable date till later.
Oh, no. List the matter for on the returnable date for updating as to whether the subsistence allowance has been duly paid or not.
Highly obliged.
To Mr. S. Ali, Mr. R.K. Mutari appears for respond number 3, 4, and 5, and Mr. P.N. Sharma appears for respond number 1 and 2. At page 88 of the Senate, it will dispose of it.
Deeply obliged.
Item number 66, supplemental list.
Top of the list. Yes, Mr.
Lordship, transfer matter, Lordship, impugn order is at page
Transfer from where to where?
from Silchar to Lakhimpur.
Silchar to Lakhimpur.
Only 35 kilometers away.
Where?
It's from Silchar to Lakhimpur.
Okay, nearby.
It's around 60 kilometers, I am told. Your Lordship will have a look at the order of transfer.
Page 21.
Page 21. And your Lordship will
What's
see.
your name?
I am in,
Das.
I am
Yeah,
in serial
32.
number 32. But in this order, Lordship, 10% are transferred. In fact, they are not transferred, they are although it is the order of transfer, they're in the same. I may just point out, Lordship will see serial number 8, serial number 3, 8, then again 10. Although it's a transfer order, it's not a transfer for them, Lordship. Now, people who are there for around 10 years also, now 10 I am told, Lordship is there for the last 10 years. In the same place, Lordship. Now, my difficulty is, Lordship, I got an ailing mother and my son is in midtown, Lordship. My only ground would be on that. But this order, Lordship, on the
No, what
face
is
of
the distance?
it's around 60 kilometers, Lordship.
I've just
I-
inquired, it's only
I'm told it's
35
around 60
kilometers
I,
from DC office.
I don't know for sure, but my client says it's around 60.
And when were you transferred earlier?
Lordship in 2021, Lordship.
So 2 years is over.
Yes, Lordship.
So that policy doesn't come. In fact, it seems to be they may use the word transfer, but it seems to be a arrangement.
More or less, Lordship.
They were not sent much higher to different places out there.
It's within the district.
It is not only within the district, it is also this rearrangement of many things. Like you were in the transformation and development branch, now you are SDO civil.
Lordship.
Much better. You should go there.
Lordship,
SDO civil has a lot of powers. What do you say? The revenue? Huh?
Same district within the district.
Same
circle.
Same circle.
Same circle.
The circle is same, but SDO
Yes.
power is much more.
Much better.
Since it's away from the DC office, Lordship.
Is better. He becomes the head of the particular area.
No,
Isn't it?
Lordship is senior assistant, Lordship.
He's a SDO civil.
No, to the office of the SDO.
Oh,
To the office of
He's to the office of the S.
he's a what is the
Senior
he's a
assistant.
senior
Senior
district
assistant.
administrative
Yes.
assistant.
Yes, Lordship.
He's a senior assistant.
He's a senior assistant. Normally, Lordship, transfer is around 3 years, Lordship.
3 years is gone.
He has also annexed that particular OM also,
Yeah.
page 26.
Yes. Mr. Arkadev Chaudhary, being always on this side,
Yes.
has got used to this OM to show it. So he has inadvertently produced it. Yes.
So the reasons has to be recorded.
Hmm?
The reasons for the transfer.
We'll have it on 30. 30. Mr. Bora, get your instructions on this. Heard Mr. Arkadev Chaudhary, the learned counsel, appearing on behalf of the petitioner. Mr. D. Bora appears on behalf of the respondent number 2 and 3.
2 and 3.
And Mr. S. Dotto appears on behalf of the respondent number 1. The petitioner issue notice making it returnable on 30/6/2023. As the respondent numbers 1, 2, and 3 are duly represented, extra copies of the writ petition be served during the course of the day. The issue involved in the instant writ petition pertains to a challenge to the order dated 21/6/2023, whereby the petitioner, who is working as in the capacity as the senior district administrative assistant,
Senior assistant.
huh?
Senior assistant.
Senior assistant.
Here they have used the senior district administrative assistant. I've been working as the senior assistant under the office of the deputy commissioners, under the deputy commissioners amalgamated establishment Kachar, have been transferred from the transformation and development branch at Kachar at Silchar to the office of the SDO civil Lokhipur. the learned counsel appearing on behalf of the petitioner submitted that from a perusal of the order transfer, the order dated 21/6/2023, it does not reveal that the said order is actually a transfer orders for various other persons whose name, various other persons, as mentioned at serial number 3, 8, 10, 16, 18, 20, and others. The learned counsel for the petitioner further submitted that the petitioner had also submitted a representation on 20. When did you submit?
On the same day, 21.
On 21/6/2023 to the Deputy Commissioner Kachar, stating inter alia that he is a diabetic patient and is suffering from high blood pressure, and as such the said transfer should not be effected. Considering the above, the respondent number 2 and 3 are directed to apprise this court on the next returnable date as to the reason for transferring the petitioner from in pursuance to the order dated 21/6/2023, and as to what steps have been taken as regards the ventilating of the grievances in terms with the representation dated 21/6/2023. Status quo may be maintained till the next date.
At number 65.
Oh, yes. Yes, you have filed.
Yeah,
Mr.
filed.
Gogoi, very difficult to find or trace you out everywhere. Yes.
My lord, the vehicle of the petitioner was detained by the forest department, my lord. That too, my lord, my driver was there, my lord. Immediately I have approached the honorable court, my lord. Honorable court directed me, my lord, to take JIPA upon furnishing the original.
No, see, on the last occasion, this court had directed the authorities to apprise this court as regards the compliance to the provisions of, which are the provisions?
Section
49.
49, my lord.
49. 49. Where is 49? Where do I get that 49?
Assam Forest Regulations. That your lordship will get.
49.
It will be good.
You have confiscated and forfeiture.
Yes, my lord.
Forfeited also. Forfeited also.
Yes. My lord,
And he has not challenged the forfeiture.
no, my lord. He says there's a procedural lapse, but interesting point in this case was normally, my lord, to resort to that process, owner has to be sorted. Owner has to be ascertain who is the owner. But his vehicle was founded and deserted, and it was handed over the police. Then, my lord, petitioner comes to court. Then, in the course of proceedings, we come to know that he belongs from West Bengal or some other area. Then we notify him, give him a chance, and he appears before the this authorized officer. That is all.
That is why I asked you to bring on record
I have
those
brought on record. Madam.
proceedings. Huh?
Yes. Constable affidavit from page 44, my lord. It is not upon me as served upon me as record under the law. No, my lord.
Let us see page 49, paragraph there. Mr. Gogoi, that day, if you remember, there was one matter I have disposed of relating to forest dwellers. Remember? You had appeared. They have filed review.
Yes, just struck Yadav. Yes.
That day, I have issued notice in that
Yes.
only because they have brought in some very, very new documents which were
Yes,
never
yes.
part of it.
Yes.
Seizure, where there is the reason to believe that.
And all the impin communication that subjected after filing of
You
the-
are saying which provision has not been, no order of the arrears shall be made under the preceding provision unless the authorized order sends an intimation to the prescribed form. about the initiation of the proceedings for confiscation to the magistrate having jurisdiction to try the offence and the notice in writing of the person. Yes, you say
Subsection-
which has not been complied with.
My lord, subsection 5,
5 which one?
5 of section 49, my lord.
Understood. 5 ABCD which one?
5, my lord, C, 5C.
5C affords
5C.
a reasonable opportunity
My lord.
of making a representation within such reasonable time as may be specified in the notice against the proposed confiscation.
My lord.
So you see, you say that this opportunity has not been given.
Apart from this, my lord, subsection 6, my lord. Next page, lordship will see. That notwithstanding anything contained in the foregoing provision, no confiscation order subsection 4 of any tool, boat, motorized boat, vessel, cattle, charge, so machine, truck, rope, timber, or forest body shall be made if the person referred to the clause B of the subsection 5 proves that satisfaction of the authorized officer, such tool, vehicles, magazine, vehicles, boat, motorized boat, reflect card, and rope chain of the said implement articles were used without knowledge and convenience of the
But Mr. Borgwin, the problem out here as regards 6 is a question of fact.
My lord.
This will go on this has to be read with 5C and 6 together, because the reasonable opportunity and the 5C will also entail that you have been given an opportunity to prove.
Yes.
Isn't it?
Yes, my lord.
So 6 will only come when 5C is complied with.
My lord, 5C has not been complied with because lordship will see Honorable Justice Pathak, my lord, his order directed. If order is with me, my lord, then I have approved.
That order is already there.
There, my lord, in the record it is there.
No, he has filed it.
I have annexed.
Yes. Oh, not my order. Issue notice making it returnable on. Where is that order?
Page 40, my lord.
Page 40. The respondent 7, the peace officer under the header is directed to obtain regarding the genuine ownership certificate of the vehicle involved. On the next, the division of shall apply this report about the status of the offense report. No, only tell me, here this was page 44.
My lord.
Is the compliance with 5C?
Yes, my lord, it's 5C.
Let them show, my lord, it was sent to me, my lord.
You have not received this?
I have not received, my lord. Rather, my lord, page 46, my lord, I have approved to them, my lord.
Page 46.
6 is the order of this honorable court, my lord. So and so, denied so and so, Perus so and so, the standing counsel so and so. Petitioner may approve.
Mr. Gogoi, why don't we do one thing? Irrespective who has done this or that, let him approach and give him one opportunity.
Yes, that can
I think that is the best way.
That can be done. He will not agree to that, my lord. He will not agree to
Even though, my
that.
lord.
No, that is the only relief I can, because the main problem is 6.
No, lordship.
The 6 is you have to prove.
Lordship will give the time limit, my lord. I'll go there.
And who, before whom it has to be done?
It has to be DFO, my lord.
DFO.
Authorized officer, come DFO.
By speaking order, my lord, has to be, in case of my lord, I am aggrieved, I may approach taken. That observation.
You are aggrieved, that is a subsequent cause of action, isn't it, sir? Mr. J.I. Borgwin, the learned counsel, appearing on behalf of the petitioner. Mr. D. Gogoi appears on behalf of the Forest Department of the Government of Assam. The instant petition has been filed. Challenging the confiscation of the vehicle of the petitioner bearing registration number WB65D0022 by the order dated, which is the order 1131-3.
Page 51, man.
Yeah. By the order dated, what is the date of the order?
13 May, man. 13 May 22.
13/5/2022. Passed by the authorized officer cum divisional forest officer, Kachar Division, Silchar. The case of the petitioner herein is that the said order dated 13/5/2022 has been passed without providing the opportunity to which the petitioner is entitled to in terms with Regulation 49(5)(c)
And
of the
No, no.
Assam Forest Regulation 1891, and thereby
my lord, if I may interrupt, my lord.
affecting, yes.
My lord, that sentence, he was given opportunity. He appeared.
Oh,
on
it
page
is his
50.
submission
Oh,
I've
yes,
referred.
yes. Sorry, madam.
Illegally line to cut. Mr. Gogoi also let him list. The case of the petitioner. And thereby affecting the right of the petitioner in terms with Regulation 49(6) of the said regulation. On the other hand, Mr. D. Gogoi, the learned counsel, appearing on behalf of the Forest Department, submits that a notice dated 2/3/2022 was issued by registered post with AD to the petitioner
By another officer. Beat officer.
thereby asking the petitioner to produce the legality and proof of origin and thereby asking the petitioner to show cause as to why the seized vehicle and the illegal teak saw timbers shall not be confiscated to the state. The learned counsel further has drawn the attention to the communication dated 31/3/2022 intimating the petitioner that in exercise of the powers under section 49, regulation 49(4), 49(5)(b) of the Assam Forest Regulation 1891, the petitioner was directed to produce the documents on 15th of April 2022 at 11 a.m. in connection with the vehicle number WB65D002 seized under the Hawaii Range, Dholai on 7/5/2021. Subsequent thereto, by another order dated 31/3/2022, the petitioner was also intimated that the confiscation proceedings under section 49(4)(b) of the Assam Forest Regulation 1891 was drawn up, and the petitioner was asked to show cause as to why the mentioned truck WB65D0022 shall not be confiscated. It is therefore the case of the respondents Forest Department that after following the said process, the order dated 13/5/2022 was passed, whereby the vehicle number WB 65D0022 as well as the sawn timber were confiscated to the state of Assam. It is therefore the submission of Mr. D. Gogoi that every opportunity was given to the petitioners for the purpose of proving in terms with Regulation 49(6) of the Assam Forest Regulation 1891. The learned counsel appearing on behalf of the petitioner rejoining the submission made by the petitioner, respondent by the counsel of the respondent forest department submits that the state communication, all three communication, that he have not received any of the communications dated 2/3/2022, bracket annexure F, 31/3/2022, annexure H, annexure H, 31/3/2022, annexure H. Why there are two annexure H? Mr. Gogoi,
Something I've crept in, my lord, inadvertently.
H1. We make it H1.
And all these subjects.
No, my lord, these are two different forms.
Understood.
Yes, H1, it should be, my lord. It's clerical, my lord, mistake, my lord. I am sorry for that.
All these things happen, my lord, after
We make it H1.
3/3/22, my.
We make it H1. You make it H1.
My H1.
In your petition also, huh?
My lord.
You have made it annexure GH. What is this G?
What is H1 would have been G. H1 H and H would have been G, my lord. This is
No, why? In between you have inserted on High Court's order. That is the problem.
My lord.
Which is not there. Anyways. These High Court's order at page 45 was not necessary. And that you have marked it.
Actually, my lord, all these things happened because of the order 3/3/22. They want to cover up.
Okay.
Lordship, kindly have a look before that.
Okay. No, I'm taking on H1 and H1. The communication dated 31/3/23 annexure F. Communication dated, notice dated 31/3/2022, annexure H, as well as the initiation of the confiscation proceeding, drawing up of confiscation proceedings, annexure H1. The learned counsel further submitted, for the petitioner further submitted, the said aspect would be apparent from a perusal of the order dated 15/2/2022.
3/3/22.
Where is it?
Lordship will see order dated 3/3/22.
Where is it?
It is there in the record.
46, man.
No, 3/3/22, my lord. They want to cover up that.
Okay. Where is that 3/3/22?
Lordship, it is there in the record, my lord, or I'll supply my copy.
Okay.
3/3/22 is annex, my lord, page 46.
3/3/22. This is 3/3. As referred to the order dated 3/3/2022 passed in the instant proceedings, whereby this court had given the liberty to the petitioner to approach the forest department for release of his vehicle bearing registration number WB65D0022, placing all the relevant original documents pertaining to the said vehicle in question, as well as also had directed the respondent forest department to consider the release of the said vehicle of the petitioner if the same was not further required for investigation of the case, keeping the videograph, chassis number, engine number, etc. The learned counsel for the petitioner therefore submitted that these subsequent communications, as have been enclosed to the affidavit in opposition as Annexure F, Annexure H, and Annexure H1, are communications manufactured in order to cover up the lapses on the part of the respondent forest department in pursuance to the order dated 3/3/2022. That's yours? Upon hearing the learned counsels for the parties, now this court have heard the learned counsels for the parties, and I have also perused the materials on record. The issue involved herein pertains to as to whether the order dated 13/5/2022 what are you doing? This order, have you looked into this order?
Yes, man. What had happened exactly?
No, 13/5/2022.
No, this was
Do you mark it to a judge also?
Man, I don't know. He did. This officers, man, over enthusiastic officers.
Over the page 54. Look
Yes,
out here.
man, yes, I apologize for that. Man.
You nowadays mark it to a judge also.
Well, things happening when contempt petitions are the authorities are writing to the register.
Understood, but then also should you mark it to the register?
I
Not to
apologize
the
for this
judge.
conduct, my lord. No. That order, my lord, page 52, he was heard, my lord.
Understood.
Apologies.
The issue involved herein pertains to as to whether the dated 13/5/2022 was passed by the respondent authorities by following the process, following the mandate in terms with Regulation 49 of the Assam Forest Regulation 1891, and more particularly Regulation 49(5)(c), which entitles the petitioner herein to be afforded an opportunity, a reasonable opportunity of making a representation within such reasonable time as may be specified in the notice against the proposed confiscation. This court, upon perusal of Regulation 49(6), also is of the opinion that a valuable right is conferred upon the petitioner to show that to prove to the satisfaction of the authorized officer that the truck in question was used without his knowledge or connivance or abatement, or as the case may be, without the knowledge or connivance or abatement of his servant or agent, and that all reasonable and due precaution had been taken against the use of the object, against the use of the truck for the commission of the forest offense. Taking into account the above and the claims and the cross claims made herein, that the opportunity was given made herein, whereby the petitioner alleges that the notices dated 22/3/2022, note annexure F, notice dated 31/3/2022, annexure H, as well as the drawing out of the confiscation proceedings by communication dated 31/3/2022, annexure H1, was not received. And on the other hand, the respondent authorities have categorically said that the said notices have been duly served upon the petitioner. This court is of the opinion that it would be in the interest of justice that a further opportunity may be given to the petitioner to reply, to show cause to the notices dated 2/3/2022 from annexure F, 31/3/2023, annexure H, and 31, and the drawing up of the confiscation order, confiscation proceedings by the communication dated 31/3/2023, 22, the annexure H1. So that if the petitioner, so that the valuable right of the petitioner can be so that the petitioner can be afforded a further opportunity to exercise his valuable right in terms with regulation 49C(6) of the Assam Forest Regulation 1891. Accordingly, this court therefore disposes of the instant writ petition, thereby granting the petitioner how much time? 15 days.
15 days.
Directing the petitioner to submit his show cause to the 18 the notice dated 2/3 annexure F, so and so, so and so, so and so, annexure H and annexure 1. Within 15 days from the date of the instant order. The respondent authorities shall, upon such upon filing of the show cause notices as directed, as permitted by this order to the by the petitioner, filing of the show cause notices by the show cause replies to the communications referred to herein above, shall within how much? 1 month, 2 months?
Commercial vehicle, 15 days, another 15.
1 month.
1 month.
Within 1 month thereof, shall pass a reasoned order in terms with section 49 of the Assam Forest Regulation Act, Regulation 1891.
Right.
With the above, the instant petition stands disposed.
The instant order of confiscation has to go up.
This court further clarifies that the order dated 13/5/2022 further clarifies that in view of the opportunity so given to the petitioner, the order dated 13/5/2022, whereby the petitioner struck bearing number so and so was confiscated, is hereby set aside. With the above, the petition stands. The articles at serial number 11 of column 1 of the order dated 3/9/2008, that is Sadar Mekhala Panek, are reserved for exclusive production by Handloom up to the range specified in column 3. The said articles Sadar Mekhala Panek, if manufactured with cotton yarn or silk yarn or art yarn, or in any combination of cotton yarn, silk yarn, art yarn, would come within the ambit of the reservation order dated 3/9/2008. However, if the said articles Chadar, Mekhala, Panek are manufactured with synthetic yarn or blend of cotton yarn, silk yarn, art silk yarn with any synthetic yarn, the said articles will be outside the reservation order dated so and so, and the state of Assam and its officials cannot restrict the manufacture or sale of such articles in exercise of the powers conferred under the Act of 1985 as well as the reservation order dated 3/9/2008. You see, you have challenged the impugned notifications not only on, which included many aspects like Gamusa also. Yeah. So I have dealt with Gamusa also, clarified that the Gamusa of Assam so manufactured would come within the ambit of the reservation order at serial number 3A, and therefore the respondent authorities of the state of Assam would be justified in initiating actions under the Act of 1985 to the extent the powers have been delegated by the central government by the notification dated 15/12/2000. Furthermore, as the Gamusa of Assam has received the GI tag under the provisions of the Geographical Indications of Goods Registration and Protection Act 1999, and is registered in favor of the Director of Handlooms and Textiles of Assam, the provisions comprised in Chapter 8 of the said Act would apply. Relevant herein is Section 39 and 40 of the said Act, whereby penal provisions are stipulated for applying false geographical indications, as well as for selling goods to which false geographical indication is applied. The article Gamusa is an article reserved under serial number 3A for exclusive production of the handloom. Under such circumstance, the impugned notifications whereby there is a ban upon sale of Gamusa manufactured in powerloom is not interfered with. It is further held that all Chadar, Mekhala, Panek are not exclusively reserved for handloom production, save and except those which are manufactured from cotton yarn, silk yarn, or art silk yarn, or in any combination thereof. Therefore, those Chadar, Mekhala, Panek manufactured with synthetic yarn such as polyester, propylene, moda acrylic, nylon, or blends of cotton yarn, silk yarn, artificial with synthetic yarns are outside the purview of the reservation order. The impugned notifications so issued banning sale of Mekhala Sador, which do not come within the range mentioned in column number 3 of the reservation as indicated and explained above, are interfered with to that extent. You see, they have mentioned out there in the affidavit in opposition in any combination thereof. I've explained the word. The words in any combination thereof are relevant to take note of taking into account the contesting claims of the parties herein. The word thereof or other prepositional combinations like thereto, therewith are used in formal meeting, in formal writing. and means of it, of them, of that, of those. So the term in any combination thereof added after the words cotton yarn or silk yarn or art silk yarn would mean cotton yarn or silk yarn or art silk yarn or any combination of them. That is, any combination of cotton yarn, silk yarn, and art silk. These records are very, you got it in the book. I will over sir. Still go but you got the file, na?
Yes, ma'am.
That is there.
That is
That you give it. On kitab okhane আছে Bible. There's a very beautiful article on artificial silk. It's an article of 1911. It is printed out there in this particular book. There's a journal, been knowing Scientific American. This is a journal which was first published in 1845. Like people like Albert Einstein also contributed to this journal. I got some help from there.
It will be a very comprehensive test.
Huh?
It will be a very comprehensive.
However, I did not deal with subcurrency industries because it is nothing but it will only embarrass the government. Tidak paling.
I know 40.
Yes.
Hey, please, Lordship.
Where is your counterpart?
Lordship, on a number of occasions, Lordship, the respondent or
Yes, secondary education, Mr. Khatunia. Why you have approached so late?
Lordship, there was earlier an order of this honorable court, Lordship, that also was not followed by them, Lordship.
The order of this court is at page 19.
Lordship. Page 19, Lordship. After she was transferred, after some payments had been made, but the earlier
The respondent particularly shall examine the case of the petitioner, and upon an examination, if it is found that the petitioner is still working as the assistant teacher in so and so. Her salaries shall be paid to her within a period of 3 months from the date of receipt of the certified copy. This was in the year 2002.
Lordship.
Then what happened?
Thereafter, she was transferred, Lordship. Next page, Lordship, page 21, Lordship.
Then
Transferred, and much later to that period, Lordship, she was paid salary, but from a much later date, Lordship.
when?
Lordship, she was paid the salary up to, Lordship, from 25/11/2005, Lordship.
Then
She had been paid. Thereafter she was paid regularly, but the earlier part they haven't paid.
understood. But then what happened? What were you doing all this while till 2022?
Lordship, she had filed applications before the
Where?
Lordship.
There's nothing out here on record. Nothing. The last of the communications you have enclosed is of 2006.
Lordship.
Then
Lordship, page 24, Lordship.
yeah. This is 2004. I'm giving you another benefit of another 2 years. Then,
But still, Lordship.
then
Let them
you are
work it out,
reopening
Lordship.
something which is closed. If you have not explained why you have not vigilant enough and now getting hold of Manoj Bhagavati, can somebody get the idiot in?
Wait.
Lordship, the director.
Where
had
is
said-
any other document to show that you have been anyway vigilant enough that you have approached the authorities concerned?
Lordship, page 6.
When did you last submit a representation?
Lordship, since it was continuing, Lordship, and the commissioner
Continuing
was
from
also
when?
busy.
2006. Thereafter, what has happened?
In page 26, Lordship, there is a letter of the commissioner also, Lordship. When the commissioner deals with the matter, Lordship, we are of the firm belief that we will get it, Lordship.
You see, the order of 2002 is
Okay.
to examine and pay.
Lordship,
It's done in 2005.
Lordship, exactly, but that was not paid, Lordship.
So,
Even
what
after-
were you doing all this while from
Lordship,
2006?
Lordship, being layman, Lordship, we are always of the belief that once an order of this honorable court is passed, Lordship,
I understand 1 year, 2 years, 3 years is okay. But what about 17 years?
Lordship, I would not have liked to say that, Lordship, but this lady is physically silenced, Lordship.
Huh?
Physically, Lordship, I do not know the word nowadays used nowadays, Lordship. She's physically silenced.
So where have you mentioned anyway?
Lordship, that she didn't want to mention, Lordship. That she said that let it not be a criteria for
Then,
me. But personally, I have met her, Lordship, and I know her disabilities, Lordship.
then how can this code help you? Tell me. And government, what have you taken action on this order pursuant to this 2002 order?
My lord, after that order, my lord, initially she was appointed on ad hoc basis, my lord. And her ad hoc appointment was extended from time to time. Thereafter, my lord, in 2003, she was adjusted in the KRB Guards High School. And during that period, my lord, the SLC approval was required. State level import committee. That approval was not there initially, my lord. It was given in the year 2005, my lord. Thereafter, she is getting salary, my lord. Due to non-receipt of SLC approval, my lord,
she could not be paid during that
Then
time.
why you are not filing an affidavit to that effect?
Yes, I will file, my lord. In fact, I have received the instruction recently, my lord. On
You file
15
an affidavit
15/6.
because she has already retired.
Yes, madam.
See, you are getting your provisional pension. Final?
Lordship, no.
Why
Provisional
final?
pension, Lordship, because of this Honorable High Court's order, Lordship, the order dated 22/2/21, Lordship.
Hmm.
There was a directive to release
Only
the
for
provisional
payment of
pension.
provisional, but what about the final? This is of 2000. How many years does it take for final? This is a simple case for
Yes,
final
otherwise,
pension.
no, it's a 2020 matter.
Yeah.
I will obtain that instruction also, madam.
File your affidavit
Yes.
to that effect.
Yes,
And,
madam.
yeah.
Lordship, that
Heard.
was my point, Lordship. They should at least respond to the Honorable High Court's direction, Lordship. Notice was
It's
issued, Lordship.
okay.
Let them file an
You-
affidavit. Why sit over the matter, Lord?
Heard Mr. M. Bhagavati, the learned counsel, appearing on behalf of the petitioner. Mr. N.J. Khatonia appears on behalf of the Secondary Education Department. The claim of the petitioner herein is that the petitioner is entitled to the area salary for the period from 3 to 1996 up to 24/11/2005. And the said period should also be taken into account for the purpose of her pensionary benefits. The learned counsel for the Secondary Education Department submitted that initially the petitioner was appointed on ad hoc basis. Thereupon, in the year 2003, the petitioner was what? 2003, what happened?
She was accommodated, madam.
She was accommodated in
KRB Girls High School.
KRB Girls High School. However, at the time of accommodating the petitioner, there was no SLEC approval, which was mandatorily required at that relevant point of time. However, it is also the further case of the respondents upon instruction that in the year 2005,
Yes, madam.
when?
From 9/11/2005.
From 9/11/2005, after receiving the
SLEC.
approval, SLEC or SIU?
At that point of time, it was
Now,
SIU, madam.
Then 2005.
SLEC.
Because SIU came on 4/7/2005.
Here, madam, they have received SLEC, but regarding, madam,
Okay, it is only after the SLEC approval in the year 2005, the petitioner have been properly brought into the services of the affairs of the government by the order dated 9/11/2005. And as such, the petitioner is not entitled to the computation of, not entitled for the consideration, entitled for computing the said period prior to 9/11/2005 for the purpose of pensionary benefits. Taking into account the said stand, this court is of the opinion that the said stand needs to be brought on record by way of an affidavit so that the petitioner is in a position to rebut to such allegations. The learned, it further reveals from the records that the petitioner retired in the year 2020.
That's it. 36/2020.
36/2020. And the petitioner has only got has only been given her provisional pension. In that view of the matter, this court therefore directs the Director of Secondary Education to file the affidavit by 19th of July without fail. List the matter again on 21st of July.
Lordship, may see page 21, Lordship. She was transferred, Lordship, in 2004.
joined and useful in 2004 or 2005 as we had said.
That is what he says.
Lordship.
Let us see.
Lordship.
You will revert.
Obliged.
Item 5, order no steps.
Hmm.
I have already taken steps.
When?
Today.
Mr.
As the Hing.
As the Hingi and the learned counsel appearing on behalf of the petitioner submits that he has already taken steps by serving extra copies of the
By registered post. On phone number 6. I have already.
No, Miss Sharma learned. How many respondents are there?
6.
5.
5.
No, 6 is there. The private respondent is there.
Oh, okay. Has taken steps upon the respondent number 6 today. So list the matter after completion of service upon the respondent number 6.
Item number 6 for admission.
Yes.
Lordship, here we need to file our affidavit, Lordship.
What is the matter about?
This is Lordship, those illegal teachers, Lordship.
Huh?
Illegal and irregular teachers.
Then?
Lordship, they were subsequently, these teachers, they were neither accommodated, as per my telephonic instruction, Lordship, these teachers were illegally appointed teachers, and subsequently, pursuant to that cabinet decision, these teachers were neither accommodated as a teacher or tutor, Lordship.
When did you last receive your salary?
In the year 2005, they received some salary. Thereafter,
You received salary till 2005.
in the year 2005, 2 months salary.
Earlier you did not.
No.
When were you appointed?
Earlier also student was there, 94.
Are these people from the same school?
No matter.
Why are you making all these 80 people like petitioners together?
In the same district, matter.
Okay, tomorrow you may file another requisition of the entire state. Huh?
And their regularization order was common matter.
What?
Regularization order was common matter.
These are all illegal appointments.
Their service was regularized. Kindly CPS 37 matter.
They were made to appear before the S. Manoran committee, Lordship.
And
subsequently, because they did not fulfill those criteria of receiving the salary to a certain period of time, so they were not accommodated. As per my telephonic instruction, I will file the detailed affidavit here, Lordship.
But what about this thing? In so and so, so and so, so and so. This is dated what? What is the date of this communication? Oh, this is excess teachers.
Excess teacher, Lordship.
These are excess teachers people business.
Where
Where is your name?
cabinet decision?
All these names are here.
Yes, sir.
Oh, these are excess teachers. And you have been working.
Yes, sir.
Lordship, that instruction I don't have, Lordship.
Then how do you bring them again under the illegal appointment? If these are excess teachers.
Their service was regularized.
Let me file the detailed instruction.
Because if they come within this particular notification,
Lordship.
that is 28th of August 2005,
Lordship.
all these other people have got the new pension.
Lordship.
Then you are entitled for salary, asking for salary from when?
From the date of regularization.
From 2005.
Right.
You have not got till now.
No, man.
What are you doing? How are you surviving? Huh?
Only with the hope, my lord.
Hope of what?
Getting something.
Is it possible for people to survive? I understood 1 year, 2 years is okay. Huh? This is a case of 17 years, 18 years now, and you are still surviving. That means you have some alternative, some work. 100%, because how can a person survive?
with their family also.
Definitely.
On occasion, the court has also directed to conduct an inquiry also. But we have not yet found the inquiry, what was the outcome of the inquiry. Earlier occasion, the court has directed.
Okay. Heard, Mr.
Yes, sir.
As hoc, the learned counsel appearing on behalf of the petitioner, and Mr. P.N. Sharma appears on behalf of the Education Department of the Government of Assam. This is a writ petition of the year 2012, wherein the petitioners, upon being regularized by the order dated 28/2005, issued by the Director of Elementary Education, have not received their salary since then, except for 2 months. The respondent, Mr. P.N. Sharma, the learned counsel appearing on behalf of the Education Department, however, has no proper instructions in the matter. Taking into account that the instant writ petition is of the year 2012, this court grants a final opportunity to the respondent to obtain the instructions and file the affidavit by 19th of July 2023 without fail. So it is observed that if no such affidavit is filed, this court shall proceed to decide the instant matter on the basis of the materials available on record. Wait, it does not end there. Court fee, how much paid? It is also relevant to take note of that in the instant writ petition, there are 80 writ petitioners. However, the court fee of only one writ petitioner has been paid. The entitlement of the petitioners herein are separate and distinct from each other. And as such, the cause of action of each of the petitioners are also different, are distinct. Under such circumstances, the learned counsel appearing on behalf of the petitioner submits that he shall do the needful by paying the deficit court fee on or before the next stage.
Right. High level.
19th July.
Item 9.
Yes, finance. You filed affidavit? No.
No, my lord, not yet.
Why?
Here, my lord, probably this is a illegal, my lord, appointment of health department, my lord.
Huh? Illegal appointment?
My lord, that series lordship is already heard and, my lord,
Reserved.
reserved.
This
It will
comes
have some
within
bearing,
that.
my lord. It will have some bearing in this case.
Okay, so we keep it
Yeah,
after
let it be
vacation.
After vacation.
This is also illegal, but which district?
Jorhat.
Jorhat. Okay, where is your appointment order?
Appointment order is at
Page 13.
page 13. Okay.
Okay.
Page 11 and 13.
Okay, page 13. And
11.
how were you appointed?
Initially, we were appointed in JTS Jorhat Civil Hospital.
How? You are being given a scale of pay. How? Selection?
No selection was taken place. We were regular.
How?
Working.
Show me the regularization order. Let me see. Where's the regulation?
Lordship, there is no order, Lordship. After working for some time, these petitioners were appointed.
Huh?
After working for some time, these petitioners were appointed. Later on, JDS Civil Hospital was amalgamated with Civil Hospital.
No. When were you regularized? You were not regularized.
Not regular.
Then how can a temporary appointment be given like this? Not possible. How is it possible? Joint director subject to discharge without notice and assigning any reasons thereof and subject to receipt of a favorable to so and so is hereby appointed as grade 4 in so and so. Now these are the people who have been thrown out. This thing 24/5/2017.
Yeah.
In pursuance to the letter dated so and so, the following are hereby removed from service as their necessary copies could not be found in respect of genuineness of the appointment. So why are you assailing?
Okay, against this petitioner, nothing has been found.
No. Tell me, where is your appointment order? I will set aside this order so far as you show me your appointment order after a due selection. You come under that act now. What is that act?
My lord, of 1997, my lord.
Oh, that act you showed it to me now.
Yes, 1997. Yes.
97, that one. Forgot the name. Assam preferential.
No, my lord, not preferential.
Public service preferential.
No, my lord. Regarding grade 3 and grade 4 appointment.
I think the preferential. No, that is it. 99, 127. Yes, this one. No.
No, it is of 1997, my lord. That much I remember.
97. Direct recruitment class 3 and class 4.
Yes, that one.
115. Yes. This appointment categorically mention how the appointment will happen. How is it possible? The appointment. No case. When? After vacation?
After vacation.
Filing of affidavit not necessary.
Otherwise, not, my lord, here, lordship may peruse one thing, my lord. The first FIR, my lord, in the series I submitted, it is annexed here in page 15.
This is an old matter.
Yes.
Heard, Mr.
S.J. Sharma.
NJ?
Sharma.
The learned counsel appearing on behalf of the petitioner. Mr. B. Gogoi appears on behalf of the Health Department of the Government of Assam. The instant writ petition has been filed assailing the order dated 24/5/2017, whereby the services of the petitioner, how many petitioners?
Two.
Petitioners herein have been terminated, have been removed from service on the ground
to be non-genuine appointment.
on the ground that the appointments were not genuine. Mr. B. Gogoi, the learned counsel appearing on behalf of the Health Department, drawing the attention of this court, submits that the petitioners were appointed by the Annexure 1 by the Joint Director of Health Service, Jorhat. This appointment of the petitioners is contrary to the applicable rules, that is the Assam Public Service Direct Recruitment to Class 3 and Class 4 Post Rules 1997, which categorically mandates in terms with rule number 4 as to how a selection has to be, how the direct recruitment is to be made. The learned counsel for the Health Department submits that in the instant case, there was no selection process. And the said appointments were contrary to the said rules, and as such the appointments, and as such the order dated 24/5/2017 requires no interference from this court. On the other hand, the learned counsel appearing on behalf of the petitioner seeks an accommodation. Taking into account the above, let this matter be listed after. This was tagged along with those matters because you see this.
Yeah. Probably, my lord, it was
Why was this brought out? The
bifurcated.
We initially think that matters were not similar with it. So
Huh?
initially they were tagged, but this matter is not similar with those.
Taking into account the same, list the matter again on 19th of July.
My lord.
Then
Yes.
Chief, first wife, second wife, pension matters.
Huh?
Pension matter, first wife, second wife.
Oh, who is the second wife?
I'm second wife because I am actually wife, my lord, because 13 years thereafter they filed this case, my lord. In the pension papers itself, kindly peruse your lordship, this prayer, my lord, the petition, page 8. It was in the year 2013 itself, my lord, PPO order. In all papers, my name is dear, my lord. She is not along with my husband, my lord, from the last 31 years, my lord. At the time after the death, she has filed this case, my lord. Otherwise, except the case of 125 proceeding, I am not denying she is a first wife, maybe, my lord. But as all papers are
What
there,
is not denying first wife maybe?
maybe, my lord, because my lord,
You are
as
not
he has
denying
claimed,
what? Then
2007 he filed one
you
case.
are
also.
using the word maybe. That means you are putting a question mark after admitting.
Admitting because, my lord,
Because you agree.
he has annexed the some 125 proceeding case, my lord. But otherwise, there is no nexus from the last 31 years. That is also correct. And pension papers also, it is evident from the year 2013 itself. My name, my son's name, he is, my lord, in class 7, my lord. I'm getting 12,000 only, my lord, pension, my lord. And see, my son, my lord, first,
I asked you for an amicable settlement last
yes, my
time.
lord.
What have you
Amicable
done? 6,000, 6,000?
yes, my lord.
Settle it.
Yes,
Why
my lord.
haven't you filed that affidavit? File an affidavit jointly. Otherwise, I can't direct that they are issuance. If you file an affidavit, I will close and say that he is not interested. When are you going to file? I made it clear on 2/6.
17 I will file.
Not you can't file it. Both of you.
Yes, sir.
Then both of you have to file a joint
Then
affidavit.
350, my lord, then 6,000 because my lord, first wife's son is already working, my lord. 50,000 was also given my husband in the year 2007 also at the time of Malat Mondal, my lord, training program, my lord. He's Monsieur, my lord, now, my lord, 40
Why
years
did
old.
your husband, your husband pay him?
No, at the time of my lord, at the time of my lord, survival, my lord.
So you admit to that.
Yeah, I admit it. my
Not
lord.
maybe.
I admit it,
Yes.
but it is at the year
File your affidavit or else I'm allowing it. Then you lose entire thing.
17, my lord, on the reopening date. Will
Both of you file.
Yes, my lord.
The learned counsels appearing on behalf of the parties submits that the amicable settlement is in the process and as such seeks for an accommodation. List the matter again on 21st of July. In the meantime, if an amicable settlement has been reached, the parties are at liberty to file a joint affidavit.
11.
Yes, Mr. Tabildar, tell me.
Lordship, we have filed the affidavit in this matter, Lordship.
The matter pertains to what?
Release of the salaries.
Huh?
Release of arrears salaries, Lordship.
And we have already released the 13 lakhs
something.
For the period from 1/1/2013 to 31/2018.
What is your affidavit say?
We have Lordship, paragraph 5, Lordship, of our affidavit.
Paragraph 5, the phone makes the government notification the admissible area due to the petitioner in the state revised scale is 12,000 revised when have been already sanctioned. The petitioner was working in the department.
And paragraph 6.
So you got the money?
Yes, Lordship, we have released.
You've already been sanctioned.
They are claiming now more.
You are asking for more.
More.
Lordship, yes, because Lordship may kindly peruse page 40 of the receipt.
No, they are saying 13 lakhs. You are saying 22 lakhs.
Yes, sir.
You have to file a reply.
Yes, the reply will be.
Yes, yes, sir.
Heard Mr. MP Sharma, the learned counsel, appearing on behalf of the petitioner. Mr. A.R. Tabildar, the learned counsel, appearing on behalf of the Higher Education Department, submits that an affidavit in opposition has been filed by the respondent number 3. In the said affidavit, I perused the said affidavit in opposition dated 13/6/2023, wherein it has been mentioned that the petitioner's total entitlement on account of arrear pay was an amount of rupees 13,78,294, which had already been 13 lakh 78,294, which have already been sanctioned and disbursed to the petitioner. Mr. MP Sharma, the learned counsel, appearing on behalf of the petitioner, on the other hand, submits that the amount of rupees 13,78,294 have been received by the petitioner, but the petitioner's entitlement is 22,33,932. The learned counsel for the petitioner therefore seeks an accommodation of 2 weeks for filing a rejoinder to the said affidavit of the respondent number 3. List the matter after vacations.
12.
So there was a direction to file additional affidavit. Can you record the appointment letter? My lord? I have filed it today, my lord, by way of an e-filing. But can it be taken on Friday, my lord?
Why? What is the case?
My lord,
During his lifetime was issued a PPO, and after he had taken voluntary retirement on a subsequent death with the husband of the petitioner without receiving a single penny on account of pension expired on
pensionary
2020.
benefit.
Therefore, has been running from pillar to post and it is to tear the and then even as active prices post preliminary organized shall also prices to can. There are the new instructions that make the repeat
Right.
and for the payment final payment. Yes, Mr. Bora, what is your instructions?
Your Lordship, that is what it is not yet come. So I would like to seek some time, Your Lordship.
Why?
Because we have written to them twice. Let me get the. I just had a talk with the.
You have
SP
written
today
to
morning.
whom?
I just had a talk with the SP Bongaigaon today morning.
Then?
So he is not yet been. His office has not yet been able to trace out the file. So I'll seek some time accommodation. If Your Lordship takes up the matter on Friday, by that time I'll get the instructions, Your Lordship.
Okay.
Already PPO was also issued. Or PPO number has already been issued.
But you have not got intake.
No.
Where is the PPO number? It's
My lord, it is reflected in the last order, my lord.
Oh yes, I have. No, in the first order only. I have, in that order of 1/3/2023, I have mentioned that.
My lord.
Okay. Mr. H. Gupta, the learned counsel, appearing on behalf of the petitioner, has submitted that the additional affidavit has already been filed by the petitioner. Mr. D. Bora, the learned counsel, appearing on behalf of the respondent, submits that he requires 1 day's time to obtain the instructions as in terms with the order dated 1/3/2023. List the matter again on 36/2023. liberty is given to the petitioner to mention the matter.
13.
Registry is directed to take the additional affidavit filed by the petitioner. Yes. Yes, what is this?
Lordship. Lordship will find it. Clause C, Lordship, in compliance.
Huh?
Clause C, Lordship, in compliance of the Honorable High Court order dated so and so double petition number 5006, 2018, this office constituted a director level committee to examine all relevant facts and records pertaining to the claim of the petitioner. By this office, order number so and so dated so and so, and thereafter passed a region order. By memo number so and so dated 31/7/2021. And Lordship will find the order in clause F. Clause F, Lordship. In pursuance of the above, this office issued a speaking order by number so and so dated 37/2021, stating that the petitioner is not entitled for payment of arrear salary for the period from 6/4/2012 till 29/2016, as he was not performing his duties during this period. The period of suspension counted as period of service without break in the order issued from this office by number so and so dated so and so will be considered for the purpose of pensionary benefit.
Now, this suspension, what has happened?
My lord, by the last order, my lord. By last order, my lord, the respondent was directed to say about the annexure 11, my lord, page 24. Annexure 11, page 24.
The suspension period has been regularized.
No.
But he was not on duty.
Understood. What happened to the departmental proceeding?
He was in that criminal case. He was convicted, Lordship, and subsequently was by order dated.
My lord, page 11, annexure 11, page 44, my lord. A doubt came in the mind of your lordship on the last
I
occasion
had the
about the
honor to
authenticity of
submit
the
a
document.
written area proposal. This is by the director of elementary education.
Yes, my lord. This was
For the
submitted before
period
this
from
court.
so and so in respect to the petitioner so and I would like to request the government to please to accord necessary sanction for an amount of so and so. Then,
My lord, this document was produced before the court during contempt proceeding, my lord. And there is a reference of this order, my lord.
Then,
there, my lord, what happened? Petitioner is a teacher, my lord. He was convicted in a criminal case and he was convicted for life imprisonment. After conviction, he preferred appeal before this court and he was acquitted by this honorable court. Then he, after coming out from jail, he applied for allowing him to resume his duty, my lord. That was not considered. Then he filed a writ petition, my lord. After writ petition, this honorable court directed the authorities to consider his case within a period of time. Then, my lord, the speaking order was passed. Your lord, you will find page.
no, understood. But this period from 6/4/2012 to 29/2/2016
Yes,
is the period when you were inside.
No, my lord. After coming out from jail.
After coming out from jail, after acquittal.
After acquittal, my lord.
And what happened to the departmental proceeding?
My departmental proceeding, my lord.
Was never initiated.
No departmental proceeding was initiated.
So they had done it under 6(1)(c).
Nothing they have done, my lord.
And the suspension.
Oh, yes, ma'am.
Under 6(1)(c). So there was no departmental proceeding.
Departmental proceeding.
So once you are therefore, this is the period after you have been
Yes, my lord.
acquitted.
After acquitted, my lord.
Then why are you not paying him?
My lord, kindly see page 28, my lord. Page where the petitioner was reinstated, my lord.
But he did not perform duty, Lordship. He did not join during this period.
My lord,
They did not
As per
allow me to
report.
join, my lord.
Okay, where is this? This is 2016.
16, my lord.
Yes. I filed a court case on so and so, and the Honorable Court passed an order whereby the Honorable Director is going to consider the prayer of the petitioner dated so and so, addressed to the petitioner. Reveals from the prayer petition that surprisingly was paid his salary up to the date of sending him into jail by the session court after the court verdict. In the meantime, a disciplinary was initiated by the DO on the ground that sponsor is in police custody for more than a year. In this case, the above rule was not applied. Since the petition was acquitted, he was up to the date of his acquittal. If any excess amount was paid to the petitioner, it will be up. The period of tenure will be set for the period of pension. Will be counted as paid. So here you have categorically held in 2016 that he will be entitled after 2016, after 3/4/2012.
And this thereafter
But
petitioner.
Lordship,
filed this
here we
petition,
have
my lord.
filed our affidavit, and in our affidavit, it has been stated that the petitioner resumed his service from 7/3/2017 only. Although he was acquitted, but he did not perform duty. He did not join.
Understood, but did you pass an order? He had to approach the court. And because of that court, the court directed you to, and this order of 2016 came because of that.
Lordship.
Yeah.
My lord, thereafter petitioner approached this honorable court by filing another petition challenging the part of inside his jail, my lord. Then, my lord, your lordship will find page order of this court, my lord. Start from page 41, my lord. Relevant para page 42, my lord. Last, considering the
Above contented is disposed of directed to move to look into the proposal forwarded by the element to release the salary of the petitioner for the period from so and so to which is also mentioned in the orders annexed to the petition. Will be directed to be made within 3 months.
my
Now,
lord, there,
pursuant to this, and this is the order which was shown in contempt,
no, my lord. Before
page 44.
Page 44 before contempt, my lord, because after the speaking order was passed by the director 2016, my lord. Area process for area payment, area amount was processed and it was sent to the government.
Understood, but 2019, 21/1/2019, there was this direction for release
Yes, my lord.
by this court.
Yes, my lord.
Now, pursuant to that, on 4/1/2020, this order was passed.
Yes.
This is in reference to sub contempt.
Then contempt petition filed by the petitioner, my lord.
And there they say that I request the government to please accord sanction.
Yes, my lord.
Now the government sanction? No.
Before according sanction, my lord, financial year left, my lord. It was all along not disputed whether petitioner is entitled the area salary after his acquittal, my lord. It was not at all disputed, my lord. In every war, area proposal was sent to the government, my lord. Then, my lord, in 2022, my lord, your lordship has seen, my lord, page 44, my lord, annexure 11, my lord. During contempt petition, during contempt proceeding, my lord, the learned council apprised this honorable court that we have sent this to the government for sanction, my lord. Now, in 2020, my lord, the same authority has reviewed its own order, my lord.
Lordship, here in compliance to the Honorable High Court order dated 21/1/2019, passed in WPC 5006/18. This office constitutes.
No. First and foremost,
Lordship.
he was acquitted. He approached you. You did not allow him to join. Why did you pass the order in 2016? And for that, he had to come to and file a writ petition.
Lordship.
And this order categorically says that page 41. Not page 41. That order, yes. This not this one. The earlier one of 2016, immediately thereafter. Where is that order of 2016?
Page 33, my lord.
Huh?
Page 28, my lord.
Page 28. This order is after that, pursuant to a High Court's order. Why did you approach the High Court?
My lord, that order was also not complied, my lord. Then
No. Why did you approach this High Court in WPC number 6420?
to allow the petitioner to resume his duty, my lord.
Then, what is this? You don't allow this thing and all these things and contempt. So it seems, Mr. P.N. Sharma, that your director of elementary education is playing hide and seek with this court. Isn't it?
Lordship, we will file our detailed affidavit, Lordship.
You have filed the affidavit.
Already we have filed, Lordship.
But that affidavit is not satisfactory.
Lordship.
So I asked you, and you have come up with this instruction.
Lordship.
2 weeks I am not here in this bench. This has happened again.
Here it is said that in compliance to the order date 21/1/19, this office constituted a director level committee to examine all the relevant facts and records pertaining to the claim of the petitioner. Why this office order number?
No, I made it clear in my last order of 29/5. You have not done anything to the effect. And this instruction is not good enough. Why should I keep on repeating all these things?
My lord, the claim of the petitioner all along settled, my lord, till 2022, my lord.
Lordship, I fix the matter immediately after vacation. In the meantime, I will open the court conflict.
Heard Mr. A.H.M.R. Chaudhary, the learned counsel, on behalf of the petitioner, Mr. P.N. Sharma, on behalf of the Elementary Education Department. Today, Mr. P.N. Sharma, the learned counsel, have placed before this court an instruction dated 23/6/2023. The said instructions so produced is neither convincing nor answers to the query so made by this court by the order dated 29/5/2023. Under such circumstances, a further opportunity is granted to the Director of Elementary Education to put on by way of affidavit. It's then in pursuance to the order dated 29/5/2023. List the matter again on 24th of July 2023. The affidavit be filed without fail by 21st of July 2023.
Public.
Radio. The fact that there was no clarity in the aspect. Then I looked into it, you see, then the basic idea behind the GST and all.
Right.
Then I have held that, you see, the question of you getting the input credit arises because you have paid the tax. You won't get the input credit unless you pay it. So under such circumstances, you will be entitled for the input credit after GST neutralization.
Yeah.
So therefore, I have directed this court is therefore of the opinion that the petitioner herein would be entitled to his PVC claims in terms with the contract and the GST paid by the petitioner through the electronic credit ledger has to be taken into consideration while computing the PVC claims of the petitioner. The petitioner would be well advised, therefore, to take steps in terms with the JPO dated 29/1/2021 for making its PVC claims if not already done. And the respondent authority shall pay the PVC claims on the basis of the contract. It is yet again reiterated that on the ground that the petitioner have paid the output tax through its electronic credit ledger by using its input tax credit, the same shall not be a ground to deny the entitlement of the petitioner to the reimbursement of the GST. The said exercise of the PVC bills of the petitioner be completed within 1 month from a date a certified copy of this judgment is served upon the respondent number 7. I have also given this illustration. There is one illustration you have given. In the above illustration, the supplier at the time of inward supply had paid rupees 120 per metric ton along with GST of 18%. Accordingly, the supplier received input credit of rupees 21,600 for 1,000 metric tons, and having paid the output tax with the input tax credit, the supplier's PVC claims has to be considered by including the GST paid by using the input tax credit lying in the electronic credit ledger of the supplier. If this court accepts the contention of the respondent railway, it would result whereby the supplier would be getting reimbursed an amount which would be less than the purchase price during the period under consideration. And Mr. Goswami, this is also settled by a Gujarat High Court judgment by a division bench of Justice Pardiwala. And that is also by, in respect to a joint procedural order of 21/1/2018 passed by the Western Railways in terms with the circular dated 27/10/2017 passed by the Railway Board. Yes. Who appears for the petitioner? Madam, any instruction?
Lordship, we have
Heard, Mr. You say kya?
No,
Proxy?
proxy not.
Okay.
My senior is not declared due to some unable.
You have a name or proxy?
Manasraf.
So, the learned counsel for the petition. It's B. Musari appears on behalf of the Secondary Education
Secondary
Department. The learned counsel for the Secondary Education Department submits that she has not received the instructions in respect to the instant matter. Taking into account that the petitioner has retired in the year 2007 and the grievance of the petitioner is for non-release of the area pension for 33 months. This court grants a final opportunity to the Secondary Education Department to apprise this court as regards the entitlement of the petitioner. List the matter again on 26th of July.
Lordship, your treasury.
Perhaps treasury would be the appropriate party because once the PPO is issued, if any area dues that the treasury office, because he has not made a party, treasury office a party here.
Okay, let you first get the
Lordship, I'll get
instruction
the
with the
15.
On a non-payment of salary again. There were 9 teachers, my lord, similarly situated who were placed, whose services were terminated and subsequently allowed to resume their services. In liberty given by this honorable court for my lord de novo proceedings, that also completed. Order of termination held to be back. Other 8 have been paid their arrears. This person has not been.
So you did not get the salary from 21/5/2012 to 17/1/2014.
14, my lord.
And 18/1/2015 to
There is an error there,
1/4/2000.
my lord. There is an error there. It should be, my lord, 21/5/2012 to 17/1/2014. That was the period of termination. 18/1, it should be 2014 when he was reinstated.
Okay.
From that date till 1/4/2015, the salary.
So your claim is during the period of termination.
Termination plus, my lord, on reinstatement till 1/4/2015. There is a typographical error there. So literally, my lord, 21/5/2012 to 1/4/2015 years not.
It is 18/1/2015 or 14.
Should be 14, my lord. It should be 14.
They are admitting about 18/1/2014 to 1/4/2015,
Because
but they are
that's,
not. For the
other
earlier.
part they are not. There is a division bench similarly situated, my lord, division bench judgment, wherein, my lord, this was granted. Para 14.
So you will be entitled from 21/5/2012 to 1/4/2015,
Lordship,
isn't it?
Lordship. And 18/1/2014 to 1/4
No, no.
2015.
21/5/2012 to 17/1/2014.
Hmm.
And the next period is 18/1/2014 to 1/4/2015, which means from 21/5/2012 to 1/4/2015.
Lordship, Lordship. And the other part, they have the second part.
David, heard Mr. UK Knight, the learned senior counsel, assisted by D. Decker, the learned counsel on behalf of the petitioner. Mr. N.J. Katunia, the learned standing counsel, appearing on behalf of the secondary education department. The case of the petitioner herein is that the petitioner was illegally terminated on 21/5/2012. This court, by an order dated 1/8/2013, set aside the said termination order. It further appears from the record that by an order dated 18/1/2014, the inspector of schools NDC Nalbari directed the principal of the school in question to allow the petitioner to resume duty so as to enable him to complete the process of de novo proceedings till the final decision was taken in compliance to the order passed by this court in WPC number 2582/2012. Thereupon, the petitioner was allowed to resume duty from 1/2/2014, and the petitioner accordingly was disbursed salaries therefrom. The instant writ petition, however, has been filed for the claiming the area salary for the period from 21/5/2012 to 17/1/2014. That is the period when the petitioner was that is the period during which the petitioner's services were terminated. The period during which the petitioner was that is the period that is from the date of termination of the petitioner by the order dated 21/5/2012 till the date of the order passed by this court, till the date on which the inspector of schools NDC directed the principal of the school to allow the petitioner to resume duty. The petitioner is further aggrieved by the inaction on the part of the respondent authorities in not making payment of his salary for the period from 18/1/2014 to 1/4/2015. This court, by the order dated 17/5/2023, had issued notice, thereby directing the standing counsel for the secondary education department to apprise this court as regards the entitlement of the petitioner in respect of the area salary and whether any steps have been taken for the purpose of releasing the area salary to the petitioner. The learned counsel appearing on behalf of the secondary education department today have placed an instruction issued by the director of secondary education to the senior secondary education senior standing counsel education secondary department secondary bracket, wherein it has been mentioned that as the services of the petitioner was terminated by the order dated 1/7/2010, is it so?
No, madam. Termination order is 21/5/2012. Page 32.
As the services of the petitioner was terminated by the inspector of schools by the order dated 21/5/2012, and as the petitioner did not discharge his duty during the period from 21/5/2012 to 17/1/2014 in the Karya HS school, hence the petitioner is not entitled to the area salary for this period. However, it was mentioned that the petitioner may be entitled to the area salary for the serving period with effect from 18/1/2012 15 to 1/4/2015. This court put a specific query upon the learned counsel appearing on behalf of the Secondary Education Department as to whether the period should be from 18/1/2015 to 1/4/2014 or from 18/1/2014 to 1/4/2015. The learned counsel for the Secondary Education Department, with all fairness, submits that the period should be from 18/1/2014 to 1/4/2015 in view of the order passed by the Inspector of Schools on 18/1/2014. Mr. Yukinai, the learned senior counsel, has drawn the attention of this court to a judgment and order dated 23/9/2022, passed by the division bench of this court in writ appeal number 211 of 2019. Bracketed Dipali Borman versus the state of Assam and others. Bracket close. Wherein a similar question arose as regards the entitlement of the salary during the period when the appellant therein was under termination. The learned senior counsel has drawn the attention to the paragraph 14, 15, 16, and 17 of the said judgment and submitted that the Director of Secondary Education was therefore directed by the division bench of this court to release the arrear of salary of the appellant therein and process the same for the period from 21/5/2012 to 18/1/2014, and after quantifying the same and to make payment of the arrear of salary to the appellant within the period of appellant therein within a period of 3 months from the date of receipt of the certified copy of this judgment and order. I've heard the learned counsels for the parties, and upon a perusal of the same and upon a perusal of the materials, including the judgment passed by the division bench in the case of Dipali Burman Supra, this court is of the opinion that the facts involved in the instant case are similar. And as such, the petitioner therefore would be entitled to the arrear salary during the period from 21/5/2012 to 17/1/2014. That is the period when the petitioner's services were terminated on account of an illegal order passed by the Inspector of Schools. Further taking into account the instructions placed by the Director of Secondary Education, this court further is of the opinion that the petitioner would also be entitled to the arrear salary with effect from 18/1/2014 to 1/4/2015. Under such circumstances, this court therefore disposes of the instant petition, holding that the petitioner would be entitled to the arrear of salary during the period from 21/5/2012 to 17/1/2014, as well as from the period from 18/1/2014 to 1/4/2015. The said payment should be made within a period of 3 months from the date a certified copy of the instant order be served upon the respondent. Who is the director of what is the respondent?
Director of Secondary Education. Respondent number 2, my lord.
Upon the respondent number 2.
3, my lord. 3.
Respondent number 3. So the instructions were placed by the learned counsel appearing on behalf of the Secondary Education Department is kept on record and marked with the letter X.
Item 16.
to order of this board, my lord, 13/3/23.
Hmm.
The lordship was pleased to direct to make payment of subsistence allowance
Hmm.
for the period from 15/9/94 to 13/8/2020.
Hmm.
Then, my lord, by subsequent order, the respondent has terminated the petitioner from service.
Oh, that one.
Yes, my that one, my.
Then
So, my lord, then I have submitted.
have you challenged this order?
Yes, my, I have challenged. My.
Where?
I challenged, my lord, but it's not listed, my lord.
Oh, let the matter be listed after vacation.
Yes,
Let that matter come.
yes, my lord.
Because without setting aside this order, it would be difficult.
Yes, my lord.
Heard Mr. P. Sena, the learned counsel, appearing on behalf of the petitioner. Mr. N.J. Khatuni appears on behalf of Elementary Education Department. It has been brought to the notice of the learned counsel for the petitioner had submitted that by an order dated. Which order?
Order dated 12th May 2023.
By an order dated 12th of May 2023, the services of the petitioner have been terminated with effect from
After retirement, my lord.
Huh?
The decision was taken after retirement from service.
Okay, where
From date of
terminated
retirement. From date of retirement. On C04/14/2022, I have retired. So it will be, my lord, from 1/5/2022.
No. Where is that order? Where is that
Order,
order?
they have.
In the order, my lord, effect was not given, my lord.
Okay, no, where is that order where you have terminated him?
He is hereby dismissed from service. On
No
so and
order,
so
no
and so.
order.
Huh?
No effect.
Oh, that
order.
order, 12th of May, I've got it.
I have placed.
By an order, the learned counsel for the petitioner had submitted that the petitioner had challenged the order dated 12th of May 2023, which had been kept on record and marked with the letter Y. A perusal of the said order reveals that the petitioner. And did you file that application?
Yes, no, that because I have filed.
What happened there?
Just on the 23, this month, on 23, I have filed. That non-engagement.
Have you submitted
Yes,
it?
yes, non-engagement. Yes. On 23/6/2020.
I challenged the order dated 12th of May 2023 by way of a separate petition, which is yet to be listed. It has also been brought to the attention of this court that the petitioner had also submitted the non-engagement certificate in terms with FR 53(2) of the FRNSR as applicable to the state of Assam on
23/6/2023.
On 23/6/2023. Taking into account the above, this court gives the liberty to the petitioner to bring on record the said document by way of the said aspect by way of an affidavit. List the matter after summer vacation. We'll fix a date.
Yes,
when did you file your petition?
Yes, last week, we have filed.
It should have come.
Yes, this week may come.
It will be.
There is a rush, my lord, but it may not come also.
Oh, very well. We'll let this matter be listed again on 26th of July.
Yes.
Item 17.
Yes.
May I please, your lordship?
Yes, Mr. Khatonia
I have
submits that as the claim of the petitioner is based upon Madrasa final FM examination equivalent to BA, on the basis of which he therefore submits needs to instruct.
I have received an instruction from the director, my lord. They are otherwise admitting the claim, my lord. They have sent that they have already sent a proposal to the government in the year 2013, but no response from the government till then.
So who is paying for the government?
I am paying, my lord.
Then what is your instructions on that?
For that, I need some time, my lord, because
Heard Mr. N.H. Borbuya, the learned counsel appearing on behalf of the petitioner, Mr. N.J. Khatonia appears on behalf of the Education Department of the Government of Assam. Yeah, that's good. Today, the learned counsel appearing on behalf of the Education Department of the Government of Assam have placed an instruction dated 11th of April 2023, whereby it has been mentioned that the proposal has already been submitted to the government on 19/10/2023 for enhancement of the grade pay of the petitioner. Petitioner, na?
Yes, ma'am.
On behalf of the petitioner. For rupees 3,300. The learned counsel appearing on behalf of the Education Department, however, submits that he has no instruction as to what steps the government have taken in that regard. The said instruction is kept on record and marked with the letter X.
But submitted on 19/10/2013, my lord. Not
Understood. Mentioned. The learned counsel appearing on behalf of the Education Department of the Government of Assam shall apprise this court on the next occasion, on the next date to pick, as to what steps the government of Assam in the Education Department have taken pursuant to the communication dated 19/10/2023 issued by the Director of Secondary Education Assam.
2013, my lord. 19/10/2013.
13. In accordance, pursuant to the communication dated 19/10/2013 issued by the Director of Secondary Education Assam. List the matter again on 28th of July.
Obliged.
Get your instructions.
Yes, my lord.
18.
Yes.
Actually, in this matter, we have filed the affidavit today.
Mr. A.R. Tawildar, the learned counsel appearing on behalf of the Higher Education Department submits that an affidavit has been filed by the respondent number, Higher Education Department. Stop. The same, however, is not on record. The registry shall list the matter after the summer vacation along with the state affidavit in opposition filed by the Higher Education Department. Petitioner is given the liberty to file any rejoinder if so advised.
19.
Speak. You first file your affidavit, then we'll. Yes, Mr. Talukar.
My lord,
5.10.
my lord, in terms of the what are your lordship last occasion, my lord, paragraph 5.
Authority in terms of taking apportionment of the money have not been looked up.
My lord, the affidavit.
Yes, what have you done?
Yes, my lord, I have submitted, my lord, but there are some notes early, my lord, could not because there are delays. He submitted, my lord, as per your lord's directive.
When?
Order on 22, my
22/6. We wait.
It could not be that. Yes, my lord.
Heard Mr. A.K. Talukar, the learned counsel appearing on behalf of the petitioner. The learned counsel submits that in pursuant to the order dated 17/5/2023, the petitioners. Petitioners.
My lord. 2.
The petitioners have approached the authorities in terms
Respondent 6, my lord, particularly respondent number 6.
have approached the respondent number 6 in terms with the clause 5.10 of the office memorandum dated 14/9/2017
on 22/6.
On 22/6/2023. Please the matter after 2 months.
My lord, my submission, my lord. One affidavit is filed with the respondent number 3, which I have not received.
I don't feel like entertaining that. He's your colleague.
I'll give it.
Has he said that he won't give it to you?
I'm sorry, my lord.
Has he said that he won't give it to you?
Yes.
Then
Matter.
Item 20.
Mr. Talukar, one matter I have made you that thing. That's one number 3. Yes.
May I please your lordship?
Yes.
Lordships, I got the salary and gratuity lordship. This leave encashment, it was sanctioned on 7/11/22 lordship. This sanction, but as on today, I have not been paid lordship.
And Lordship, group insurance also not paid.
Well, I had actually made communication of this, all this, and the commissioner office has communicated to me saying that the information that is required is to be sent by the district secretary office. So for that, I pray for some.
Mr. R. Sharma,
Lordship.
the learned counsel appearing on behalf of the petitioner, Mr. N.K. Dabnath, appears on behalf of the PNRT Department of the Government of Assam. This aspect, who is going to pay? You are going to pay through Accountant General.
The employee will be paying. We being the employee will be paying.
Directly.
But as of now, my lord, since I don't have the entire facts with me.
Who pays the amount directly to him as leave encashment through the Accountant General? You have any role?
Lordship, I have instructions from the Accountant General regarding this. According to this instruction, we have already authorized the PNRD department by letter.
Actually, payments are not made by us. We only issue the necessary documents that are required for making payments.
Okay. Miss So-and-so, your name?
P. Swargari.
P. Swargari appears on behalf of the Accountant General A.E. Sam. The claim of the petitioner herein is that the petitioner have not received the retirement benefits due to his late father, in respect of leave encashment and group insurance. The learned counsel for the petitioner submit that the leave encashment was sanctioned on 17/11/2020. 7/11/2022. But till date, the said amount has not been credited. But have you submitted on the papers for that?
Lordship, everything I have submitted, Lordship.
You are the son. The leave encashment is to be received by the father. Have you submitted the necessary documents to them?
Lordship, adult benefits, I got it.
You have got that?
He's got leave salary. Leave salary, I got.
He has got it.
I got.
So leave encashment, na?
He's got certain benefits, my lord. It's only certain benefits that are remaining actually.
Huh? Yeah, but on 7/11/2022. However, the same have not yet been paid to the petitioner. Mr. N.K. Debna, learned counsel appearing on behalf of the PNRT department, submits that he would take necessary instructions in that regard. Ms. P. Swargari, the learned counsel appearing on behalf of the Accountant General A.E. submitted that the Senior Accounts Officer, Legal Cell, have issued a communication to the counsel for the Accountant General AE to the effect that the leave encashment benefit, to the effect that the said office is yet to receive the sanction letter of unutilized leave, earned leave from the government. And once the same is received, the office would be in a position to authorize leave encashment in regard, what is R/O?
Respect of?
In respect of the petitioner's deceased father. It has been further mentioned that the payment of group insurance lies with the administrative department of the deceased government servant, and the office of the Accountant General AE has no role in that regard. Taking into account the above, this court therefore directs the PNRD department to apprise this court on the next returnable date as to why the said department have not sent the unutilized leaves, have not sent the sanction letter of unutilized earned leave to the Office of the Accountant General AE. On the same date, the learned counsel for the PNRD department shall also apprise this court as to when the payment pertaining to the group insurance shall be paid to the petitioner. List the matter again on when? 7th of August. 7th of August.
21.
Yes, Upen Sharma. Yes, Mr.
As per this instruction, my lord, I think their cases has not been placed before the finance department, my lord, as per way Upenda's case, my lord.
Then why?
In fact, my lord, as per my information goes, my lord, there is a case pending before the Honorable Division Bench where they are claiming, initially mother teacher are claiming for regulation.
Yes.
Initially, my lord, some association of a mother teacher, they have filed a petition claiming regulation. My lord. That petition was dismissed. Against that petition, my lord, they have filed a writ appeal, my lord. The appeal is still pending, my lord. On that appeal, my lord, they have submitted to the honorable court that they may be considered as per Upenda's case, my lord.
In the writ appeal?
In the writ appeal. That writ appeal, my lord. But my information, my lord, that was not considered, my lord, till date. And writ appeal is still pending, my lord.
If the writ appeal is pending, get them pending minute is pending.
Huh?
If the writ appeal is pending, then
you are not aware.
No.
Number?
Malad, give me 5 minutes time. I'll find it out and.
Mr. D. I am the learned counsel appearing on behalf of the petitioner. Mr. N.T. Khatuni appears on behalf of the respondent numbers 1 to 4. It has been submitted by Mr. N.T. Khatuni that these petitioners.
No, Malad. There is an association, Malad. All Assam Mother Teacher Association.
It has been submitted by Mr. N.T. Khatuni that an association in the name and style of all Assam School Mothers Teachers Association had approached the division bench of this court claiming the benefit of Upenda, claiming the benefit of the judgment and order dated 8/6/2017 passed in writ appeal number 45 of 2014. The said writ appeal is registered and numbered as
W number 238 of 2016.
2016.
Odo Okom Prathomik Aru Mozolia Bidyaloy Matrihonta.
Name of association by the name of Photo of 20. Appeal number.
That critical Malad, they have preferred.
Taking into consideration the same, this matter be listed after 2 months.
22.
Obliged, Lordship.
May I please, the Lordship.
Yes.
Lordship, this matter relates to non-payment of arrears, Lordship. Petitioner earlier was suspended from his service on the allegation of misappropriation of funds by the Rational number 5 on 11/7/2019, and his suspension was entered by the Honorable Court, thereby directed the.
What are you challenging?
Kindly see page number 22, annexure 10, Lordship.
To release of arrear pay and allowance and annual increment, and treat the suspension period as on duty, and also set aside the impugn order dated 15/7/2022. Where is that? To answer it is to inform that given by no pending. Yes, who is appearing for here? Government? Well, but Mr.
Islam on behalf of LR Mukta.
And so the learned counsel appearing on behalf of the petition, none appears on behalf of the health department. This court, by the order dated 28/6/2022, had directed the respondent to file their affidavit in respect to the communication dated 15/7/2022. But till date, no affidavit has been filed. This court, taking into account the above, finds grants further 4 weeks' time for filing the affidavit. This is the matter again on 22nd of August. Always.
24.
Yes.
Matter relates to non-payment of arrears salary as well as pension.
Area salary is filed for grant of pension as well as the area salary. The petitioner retired from service on 30/6/2001 after serving as a stipendiary teacher as when service was confirmed by the order dated. Yes, instruction.
Yes, well, I have received instruction. This is a case of illegal and irregular appointee who have been subsequently accommodated, but in the meantime, this person retired, my lord. So he has challenged the accommodation order.
He challenged the accommodation order.
Yes, my lord.
He has accepted it.
My lord, whether accepted or not, my lord, that is not.
When did he retire?
30/6/2021. And
the order must have been passed on 31/2021.
Yes, my lord. Few months before his retirement, my lord.
So did he join?
That instruction I do. My lord may give some time, my lord. I will file a detailed affidavit.
Heard, Mr. Kashyap, the learned counsel appearing on behalf of the petitioner. Mr. N.J. Katonia appears on behalf of the secondary education.
Elementary, my lord.
Elementary Education Department and seeks for an accommodation for filing the affidavit. It is the specific submission of the learned counsel appearing on behalf of the Elementary Education Department that the appointment of the petitioner was illegal, and subsequent thereto the petitioner was accommodated by an order dated 31/2021 pursuant to the cabinet decision dated 7/10/2020. The learned counsel therefore submits that he would like to place due respect by way of an affidavit. This is the matter on 16th of August 2023. In the meantime, the said affidavit.
27.
Mr. You are appearing for
the AG law.
Mr. P. Chakraborty appears for Likito for the accountant generally. Yes. What happened?
Here, my lord, petitioner claimed my lord, his protection, pay protection. Now the stand of the
You file affidavit.
Yes, yes.
Yes, Your Lordship. We have filed it on 17th. Now everything rests on finance, Your Lordship. Finance, they have to actually say what.
Today I don't see the finance council. Finance have left. Hello, we get it now. Your name?
M. Suru.
M. Chaudhary, the learned counsel, appears on behalf of the petitioner. Mr. D. Bora appears on behalf of the respondent numbers 1 and 2.
1 and 2.
None appears on behalf of the finance department on call. It reveals from the record that the affidavit in opposition has already been filed by the respondent number 2. In the affidavit in reply, it has been mentioned. Yes, what is your stand? Affidavit in opposition. Huh?
Opposition.
In the affidavit in opposition, it has been mentioned that what is your stand?
In page 62, the views of the finance department, they say that.
Wait. No, page what? Page 50. Page 58.
Of our affidavit.
Yes, your affidavit starts from page 57.
It starts from page 58. The paragraph is at page number 58, Your Lordship. 6, Your Lordship.
It appears from the affidavit in opposition filed with respondent number 2 that the pay protection as sought for by the petitioner have been rejected. The proposal for pay protection of the petitioner have been rejected by an endorsement dated 3/8/2020 by the additional secretary to the government of Assam Finance Establishment A Department, stating inter alia that the petitioner, that the said proposal cannot be considered on the ground that the petitioner was earlier working in the Army Public School, which was set up under the Army Welfare Education Society, registered under the Society's Registration Act as per point 11 of the AWES, and also as the petitioner did not serve in a government institution, the provision of FR 22 was not applicable in this case. You are not filing affidavit.
Lord, I need to file reply. I need to file reply. Of
That
this
is what I am asking.
Yes.
The learned counsel appearing on behalf of the petitioner submits that you would like to reply to the said affidavit. Because the finance question does not come.
They would actually justify, they might file an affidavit to their effect.
They say that they are not, because FR 22.
From the beginning, their stand is this.
Then it makes no sense.
I have already mentioned in my petition regarding this. Let me fix it after 4 weeks.
Because their stand is this, you are to justify.
Well,
this is the matter after 4 weeks. In the meantime, the petitioner shall file the rejoinder.
well, I'm okay.
29.
Here, the petitioner is assailing an order at 28/10/2022, whereby transfer order has been stayed. Earlier, on 14/10/2022, I have been transferred from the office of the district commandant to the subdivision office.
What is this matter about?
Well, matter is, I have been transferred from one office to another, but I have been not allowed by the subdivision officer, Okajan, to join. And then I have submitted various representation. Those have been not been considered. And ultimately, I have to move before this honorable court. And
why you are not allowing him to join?
No, Lordship, this is not the situation. What has happened was that initially he was in a place of posting. He was there. Then he went to another place. Now, in that case, he had some difficulty. He says he has some medical difficulty. So he said he gave some representation that let me go back to my original place. So when he went back to the when the DC passed the order in the original place, that okay, you come back to the original place. But thereafter, that order was stayed by the DC himself. So this is what he is impugning right now. There is another earlier writ petition also. Therein the previous facts were there. But in this writ petition, what has happened is that that order has been, now he's saying that why have you stayed this order? The order staying the transfer is the impugn order here. So here we are saying that page number 78, continuous page numbering 78, your lordship, that ADC Bokajan has given a letter to the DC saying that the other person who is already there, who would be transferred had the transfer gone through, he is very responsible and he's doing some important work. So please do not shift that person.
Where?
Page number 78, your lordship.
78 is different.
Continuous page numbering 78, your lordship.
That is what certified that Sri Deepak Sharma has got RI. That is it.
Annexus 7, your lordship, of our affidavit.
No. 7. That is page 88. Not 78.
Okay. It's
10 page this way. Go. Yes.
Sorry, your lordship. With reference to the above, I have the honor to inform you that Sri Shampri Crow.
Who is appearing for? Is the private respondent there?
Not, they have not appeared.
Then how can I take it for disposal?
One.
Is the office note there? Oh, service is complete. Hello, we'll have it after vacation then.
Okay.
Let
And lordship, may I say, another case is there. So one, since your lordship is anyway taking after vacation, let it be tagged with the other matter. It will be beneficial. Other matter to that.
That has been disposed of.
Oh,
that has been disposed of.
What is that?
Because new cause of action has arisen, so the honorable court has directed to file a press. That's why I have filed a press.
Fine.
So you have challenged the stay of the transfer.
Yes. On medical grounds, I have been allowed by the Deputy Commissioner on 14/10, and then 17/10 I have been released. I received the release.
Now where are you?
Now, because since I have not on the same department, on the same post, because I have been issued a show cause, because the honorable court was supposed to hear the interim prayer, but before that they have issued the show cause saying that if you don't join, then we will draw the departmental proceedings. So under compulsion, I have to join there.
Where?
In the same post. Same
Earlier post.
Yes, my lord.
Which was stayed.
My lord.
The transfer of which was stayed.
My lord.
So place B. You were in A.
Yes.
You were transferred to B.
B. But
From B to came to again A.
A.
That a B to A order has been stayed.
My lord.
That is what you have challenged.
My lord.
So you are now in B.
I mean now original from where I have been shifted.
B.
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 My lord.
This is the matter of the vacation. On 26th of July.
My lord.
30.
Please, lordship. In this case, I have received the telephonic instruction, lordship. Pension case will be settled within a 7 days, lordship. So matter may be taken after vacation.
Mr. R.K. Talukdar, counsel appearing on behalf of the Accountant General AE submits that the pension case of the petitioner is likely to be settled within 7 days from today. List the matter again on 19th of July, on which date the learned counsel for the Accountant General shall apprise the updated status.
31.
Yes.
My lord, earlier a question, my lord, on 19/5/2023, your lordship was pleased to, my lord, ask the government side, my lord, to take instruction. Last part of the order.
Yes. Government. Any instructions?
Ganesha Sinha. Yes, my lord. My lord, director has said that they have not received the area salary proposal from the DU, my lord. Directorate has not received the salary from the area salary proposal from the DU, my lord.
It was sent on 3/1/2022. The order was clear.
In June,
Are you not appearing also for the DEO?
Yes, yes.
Or is it only you are appearing for the director?
No, no, my lord.
Then
this is a recent instruction.
you have to take the instructions from the entire
Yes, my lord.
office. One person says this and I keep on passing orders to the effect. This order was clear.
Yes, my lord.
That on 3/1/2022, the district elementary had requested the director for sanctioning the amount. Unless you say that this particular document is fraud.
Well, in fact, they are not saying that, but he said that, but he did not submit the same to director as per our available record. As per available record, it's not available with the director.
Is he saying that that particular document is false?
No, my lord.
Take your instructions, because that instruction has a very vital element.
Yes, my lord.
It is because of that document I have issued notice.
Yes.
Otherwise, there is a delay of 10 years in approaching this court. I've asked him to file an affidavit also to the effect. But only that document makes this court, because that was done on 3/1/2022 and this court issued notice. You just find out as regards the veracity. Heard Mr. M. Borguia, the learned counsel, appearing on behalf of the petitioner. Mr. N.J. Katunia, the learned counsel, appears on behalf of the Secondary Education Department. And Mr. A. Solia appears on behalf of the Finance Department. This court, by an order dated 19/5/2023, had directed the Secondary Education Department to apprise this court as regards the area salary of the petitioner for the period from 1/6/2011 to 28/8/2013. Mr. N.J. Khatania, on one hand, though represents the director of elementary education, secondary education, as well as also the district elementary education officer, is not clear as to whether the communication dated 3/1/2022 was issued by the district elementary education officer, Kachar, in as much as the office of the director of the secondary education department.
It's elementary, my lord.
Oh.
It's elementary.
I go to director of elementary education. In as much as the director of elementary education states that the said office have not received the said communication dated 3/1/2022. Under such circumstances, the learned counsel ought to have inquired with the district elementary education officer Kachar as to whether the said document was at all sent or not. Be that as it may, a final opportunity is granted to take instructions in terms with the order dated 19/5/2023. Place the matter again on 26th of July.
Obliged.
33.
Yes, Mr. Sharma.
Non-release of the salaries of the petitioner from November 2022.
Lordship, I have received the instruction that he has not submitted, handed over the charge. Fully handed over the charge. That's why he was instructed to.
Requested for the purpose of issuance of the last pay certificate so that the petitioner can get his salary from ITNO. He says that he has handed over the charge on 27th of September 2022.
He was instructed to come on 1/3/2023. He was asked to come and complete charge handing over for your, from all your charges which you kept with you in presence of the principal IIT Bongaigaon. He has not yet given, Lordship. That's why it was not.
You give it.
I don't have, but that instruction I don't have whether it was.
Okay, you go and give it. And then you pay. You issue that certificate.
That's why it was not.
We dispose it of.
Lordship.
Giving it this thing to pending doesn't happen. Heard Mr. M.P. Sharma, the learned counsel appearing on behalf of the petitioner. Mr. S.S. Roy appears on behalf of the respondent numbers 1, 2, 3, and 4. Mr. A. Thulia appears for the respondent number 5 and 6. The instant writ petition has been filed by the petitioner. Being agreed by the non-issuance of the last pay certificate by the ITI Bongaigaon. It is the case of the petitioner that pursuant to the order of transfer on 10th of August 2022, the petitioner handed over the charge on 27th of September 2022. It further appears that on 10th of November 2022, the petitioner was released from the ITI Bongaigaon with effect from 10/11/2022, thereby enabling him to join his new place of posting, that is ITI Nagaon. The grievance of the petitioner that in spite of the petitioner having joined in ITI Nagaon, but the petitioner have not been able to receive his salary in view of the last drawn pay certificate have not been issued by the ITI Bongaigaon. This court, by the order dated 22/3/2023, had issued notice what matter has come today?
Lordship, thereafter.
Did that come earlier?
Not yet. Not yet.
I had made it issue notice returnable after 4 days. Then what happened?
But on 27 it was listed, Lordship, but then
Did not reach. Had issued notice making it returnable. Had issued notice. Today, Mr. S.S. Roy, the learned counsel, appearing on behalf of the petitioner, respondent numbers 1 to 4, had submitted that the last drawn certificate have not been issued to the petitioner, in as much as the petitioner have not completed the entire
Charge handing over.
charge handing over, have not completed the charge handing over along with physical verification of all charges handing over, materials, etc. in presence of the principal ITI Bongaigaon.
Lordship, in page 31, Lordship, there is just 1 second, Lordship. The principal itself.
Mr. Once he gives you, will get it, na? Taking into account the said specific stand, which is discernible from the communication issued by the principal ITI Bongaigaon to the council appearing on behalf of to the council, which is kept on record and marked with the letter X. This court is of the opinion that the interest of justice would be met if the petitioner within 10 days from today appears before the principal industrial ITI Bongaigaon and completes the formality. The principal ITI Bongaigaon shall issue the last drawn certificate to the petitioner immediately thereafter. With the above, the instant petition stands disposed.
Lordship may also record that at page 31, Lordship may kindly peruse that
in presence of the principal lordship, I have handed over the judgment. What remains lordship that was needed to be communicated to me at that point of time itself. But that was
আর
not.
ওপৰত এটা লাইন এটা লিখি দিব সেই তাত না এইটো ক'লে এই কমিউনিকেশ্যনখনৰ কথা লিখিলেতো লিখিলো ন ইহঁত যে দিলে এইখন which is kept on record and marked with annexure. The learned counsel appearing on behalf of the petitioner, however, submits that from a perusal of annexure
Annexure 8 page 31.
annexure
8 page 31.
annexure 8 of the writ petition, it would be clear that the petitioner had submitted his charge, handed over the charge, which was duly received under the seal and signature of the office of the principal, ITI Bongaigaon. Be it as it may, taking into account the stand which has been taken by the respondent numbers 1, 2, 3, and 4, and more particularly the communication dated marked with the letter X. This court is of the opinion that the interest of justice would be met if the petitioner within 10 days from today submits his appears before the principal ITI and completes the formality. The ITI so and so shall forthwith issue the so and so, so that the petitioner with above the petition.
34.
Your Lordship, I am appearing
the compassionate pension, my lord.
I am appearing for the response number 11, Lordship, 1619.
In the meantime, my lord, what happened, my lord? I have filed another writ petition challenging the subsequent communication was given to the second wife. That your lordship would see page annexure 6, man.
Annexure
6. 6 at page 36.
Yes.
Wherein my lord, second wife also included in the kin certificate, whereas I received the certificate at page 31. So I filed a writ petition, my lord, that is 169923, my lord.
Where is it?
It is not listed, my lord. We listed together along.
Okay, list the map along with WBC number
169923.
169923.
My lord.
On 28th of July 2023, Mr. Edeka, representing the respondent number 11, is at liberty to file their objections affidavit to the instant petition in the meantime.
So I will file affidavit, Lordship. But so far, the Lordship, respondent number 11 is concerned, Lordship. She is the second wife, Lordship. There is no denial, Lordship. But she has a Lordship disabled child, Lordship. I having a certificate more than 50% of disabled, but he is a necessary party. So petitioner may Lordship implead him a party respondent. Because otherwise, Lordship, the rule says in 2007 it is amended, he will get lifetime Lordship pension, Lordship. His disabled child. That is why, Lordship, my responsibility is that the petitioner
You
may
will get only after the death of your mother.
No, Lordship, we are
Together they can't get. Pension is only to one person.
so second wife is not entitled. There is
Second
no
wife may
dispute.
not. But this disabled child
Disabled child.
has to be maintained by the first wife who gets. It's a different aspect.
Lord.
But he, as of now, he has nothing to do.
No.
He may get it. There's no quarrel. If you want to put it on affidavit, we'll look into it.
Yes.
I'm fixing it on 28.
Lord.
55.
Obliged, Lordship.
Yes, Mr. Sharma. The glass, removal of glass, nowadays I can hear Mr. Sharma.
LHP is transferred, Lordship, because his mother was there. He
Huh?
sought for transfer to Rongia, Lordship, one school in Rongia. Lordship, he preferred online application.
Issue involved in the petitioner submitted an application for transfer of area under the Assam to and it further appears on the website that the petitioner's application was recommended to be placed before the SLC. In the meantime, they fill up to and so the case of is that the delay in consideration of the new money. Yeah, what happened?
Lordship, this
You challenged the advertisement, I remember. 9 of something, na? What is that advertisement? Then what happened?
But they say that it's still under process.
How many years of service you had?
Okay. I joined on 27/3/2017.
Hey, what happened? Hey. Yes.
27/3/2017 I joined. Lordship.
So 10 years of service is where?
It's not there, Lordship. but
Then how
my-
is your thing to be taken into consideration? 7 is there, na? Section? Mr. Khatania?
Yes, madam. 10 years of service.
Then likely not recommended.
Lordship, but then his case is an exception, Lordship, and that was recognized by the authorities themselves. Lordship.
What exception?
It's under the guidelines, Lordship. It's being provided that if someone.
No, the act categorically mentions that section 7 categorically mentioned that he has to have 10 years of service. How do I help you?
But under
Can the guideline, if there is any guideline which is contrary to the act,
in that act itself at 10, Lordship.
10 will be taken. These are other conditions, but without satisfying 7, how can you go to 10?
Lordship, these are the
Does section 10 start, notwithstanding anything contained in the other provisions of this act? These are the provisions which needs to be taken.
doesn't start like that, Lordship.
Does it say anything else?
They consider
That irrespective of section 7, the section 10 will apply.
Lordship, they
There is no non-obstinate clause. So section 7 will apply. Section 7 and there are other parameters which are there in 10. What do you say, Mr. Khatania?
Yes, my lord. That is there, my lord. 10 years of service.
No case. Dismissed.
Lordship, they recommended, Lordship.
Recommended, that is good. Do you know what happens? The best part was, there was one case moved by one council. And Mr. S. Bora was appearing for the BTC. Everybody recommended everything. So he asked this court and so and so. I asked Mr. Bora that, what do you say? Lord, we'll consider. So, okay. Once considered, the authorities thought it that when this court said that considered, thought it should be given. And that was happened. Once he has been given, then there was a floodgates of litigations out here. And all they are saying that 10 years have been. However, my order was, if it is confiscable under law. No. Why should I ask?
Page 49(1).
No. First of all, you are not qualified as per the act. I won't look into anything. Heard Mr. MP Sharma, the learned
They
counsel
can always
appearing.
accommodate as per pupil teacher ratio, Lordship.
I give you one thing, that after the period is over, you are at liberty. That is the best I can give you. Nothing more than that. Last week before vacation, you don't want to spoil the mood of your client. What?
Lordship may not dismiss it, but Lordship,
No. This court is not going to pass an order of consideration. When we direct something, it never happens. You pass an order of consideration, it is more effective. What? Dismiss?
no, Lordship.
Okay. At the request of Mr. MP Sharma, the learned counsel for the petitioner matter will be listed after 4 weeks.
36.
Yes. Yes. Any instructions on this? Hmm? No instructions?
I have received an instruction. Madam. And no concrete instruction. Madam. This instruction will not be
Heard,
sufficient. Madam.
Mr.
Yes.
When so the learning counsel appearing on behalf of the petitioner, Mr. N.J. Khatania appears on behalf of the respondent number 1, 3, 4, and 5. The learning counsel for the respondent submits that there is no concrete instructions in terms with the order date in 19/5/2023. So taking into account the above, let this matter be again listed on 2nd of August 2023. In the meantime, the learned counsel appearing on behalf of the respondents 1, 3, 4, and 5 shall obtain without fail the instructions in terms with the order date in 19/5/2023.
37.
Here I have received instruction, my lord. I may be allowed to some time to file the affidavit, my lord.
Why?
My lord, in fact, they have to rebut our stand, my lord. Our stand is that, my lord, they are not qualifying under the 2017 Act, my lord.
Oh, that matter.
Yes, my lord. In fact,
that matter they have asked for
salary, my lord. They have their service provincially under the 2017 Act.
You say about 21.
Yes, my lord.
No, something 21 or something. I
Yes, my
remember.
lord. Here,
I asked you to file an affidavit.
no, in one matter I have filed, my lord.
Oh,
So
that matter.
I have filed, my lord. Here, my lord, I have to file, my lord.
Mr. N.J. Khatunia, the learned counsel, appear in the air on behalf of the Secondary Education Department 6 for an accommodation to file an affidavit in pursuance to the order dated 19/5/2023 and 12/6/2023. List the matter on 9th of August 2023. In the meantime, the said affidavit be filed without fail by 7th of August 2023.
38.
Lordship, in this case, I pray for some more time. Lordship, we have not received the instructions.
What matter?
Lordship, let him take the instruction. Otherwise, issue is very simple. Lordship. Issue is simple. I was dismissed following a departmental proceeding, but in my appeal, Lordship, that was allowed. I was reinstated back. Then the SP passed an order that I was reinstated back. On the same day, he passed another order by which I will not be entitled for salary. Whether as an inferior authority, he could have override the order of the superior authority. That
However,
is the
liberty was given to the disciplinary authority to explore a re-examination, hope of re-examination of the prosecution.
Now I have retired, so I'll be entitled to few months salary. That's only, Lordship. Let him take the instruction.
Yes.
Lordship, not received the instructions. Lordship, there's some more time. Lordship.
Heard Mr. B. Chakravarti appearing on behalf of the petitioner. Mr. S.S. Roy appears on behalf of the respondent numbers 1 to 4.
All this.
The learned counsel, this court by the detailed order dated 22/5/2023 has sought for instruction as to why the petitioner has been deprived of the benefits on the ground of no pay and no work, and whether the petitioner would be entitled for the pay during the said period. However, no instructions or any affidavit has been filed by the respondent numbers 1 to 4. Taking into account the above, this court therefore fixes the matter again on 9th of August 2023, on which date it is made clear on which, if the instruction sought for is not received, this court shall make an endeavor to dispose of the writ petition on the basis of the materials available on the court.
39.
May I pray, Lord? Instruction is not yet received, Lord.
You are paying for?
But I'm appearing for 1, 2, 4, and 5.
What is that?
KAC.
1, 2, 4, and 5. What is this? Council appearing for what is this?
KAC, Lord. Okay.
KAAC. Madam, you are paying for?
I am for
Health.
number 3, Lord.
Health.
Health, Lord.
No, and nothing to file.
No, my Lord. I have nothing to
2
file.
weeks time will be granted to obtain instruction.
Mr.
RS Strongham, Lord.
R.S. Chauhan, the learned counsel, appearing on behalf of the respondent number 1, 2, 4, and 5, 6 for an accommodation for the purpose of obtaining instructions
Yes, sir.
in pursuance to the order dated 29/5/2023. Oh. This is a suspension matter.
Yes.
List the matter again on 30/6/2023, on which date I've given you such a long time.
The extra copy we have received on 23/6/2023.
Why did you give so late?
No, my lord, I have given earlier, my lord. I don't know. My lord.
I've asked you to give the issue notice
I have 29/5
during the course of the day.
on 29/5/2023. I have given, my lord. I have
29/5 he has given.
I have the notice, my lord.
List the matter again on 30/6/2023, on which date the learned counsel for the petitioner and respondent numbers 1, 2, 4, and 5 shall obtain the instructions in terms with the order dated 29/5/2023 without fail. It is observed that if no instructions are obtained, and if there is no instructions obtained, the court shall dispose of the petitioner on the basis of the materials available on record. Get it on Friday without fail. Liberty is given to the petitioner to update the matter or to update the matter.
67.
What? Yes.
My lord, the state case was dismissed, but by the previous IA, the case was restored. There was also accepted. We are a engaged counsel, my lord. Some time may be given.
Yes. This has come up for what? Admission.
My lord.
Is the directive restore the petition to the original file, list it on so and so. Now what happens?
My lord, we file our wakalatnama.
Now, understood, that has been restored. Now what do you want?
My lord, the
Affidavits filed, everything filed.
date may be given after.
The hearing matter.
2015.
What is the matter? What are you asking for?
My lord, release of salary, my lord, for the period which we were working, my lord. You are appointed
Release the
IEPG
petitioner's
special
salary and current salary forfeit as they have been engaged as special suitors demand on the. You have paid only court fee of 60 rupees. How many petitioners are here?
My lord, we are 40.
Okay, choose one of them. One of them. Whom do you like?
My lord,
Choose only one of them. In whose favor we shall pass the order.
My lord, they have just got instruction. Just got instruction.
Only one. Ask anybody. Tapan Kumar Ray, Sophia Akhtar Banu. 40 petitioners, one court fee. How is it possible? Then, heard, Mr.
PR, sir.
P.R. Sharma, the learned counsel appearing on behalf of the petitioner, Mr. N.J. Khatonia appears on behalf of which department?
Secondary education, madam.
Secondary Education Department. It appears on record that each of the petitioners herein have claimed their individual salaries, individual area and current salaries on the ground that they are engaged as special teacher under the centrally sponsored scheme of inclusive education of disabled at secondary stage, taking into account that there are that the claim made of each of the petitioners are separate and distinct from each other, and also taking into note that only one court fee has been paid, only the court fee of only one petitioner has been paid. The learned counsel for the petitioner submits that he shall pay the deficit court fee on or before the next date. List the matter again for admission on 26th of July.
Highly applied.
Pay your deficit court fee.
Highly applied.
Yeah, 42 হয়ে গেল 41 adjourned.
I know 42.
Chalo. Okay, service not complete leaves the matter after completion of service.
43.
Yes, we have not taken first steps.
No, Lordship, kindly finish the last order.
Lozima court's order. No, 43.
Last order dated 12/5/2020.
Oh, the 12.5 is what?
12/5/2023.
Shall apply this court as to whether it. Oh, yes. Yes, secondary education.
Lordship, we have not received any instruction.
Why? It's a new matter.
Lordship, we have written to them, but we have not received any instruction. Your Lordship. Sometime may be given, Your Lordship.
Who is respond number 6?
That's for my Lord Headmaster.
Oh, not
They
necessary.
can, Lordship. They
Necessary.
can repair.
Okay, heard Mr. M. Khan, the learned counsel appearing on behalf of the petitioner, Ms. D. Musari, the learned counsel appearing on behalf of the secondary education department, and Mr. A. Solia appears on behalf of the finance department. The instruction sought for by this court on 12/5/2023 is awaited. List the matter again on 2nd of August 2023, on which date the learned counsel appearing on behalf of the secondary education department shall obtain the instruction in terms with the order dated 12/5/2023 without fail. List the matter for admission on the next day.
44.
In this case, my lord, I have received instruction, my lord. As per my instruction, my lord, the pension and other payment benefit was stopped by the instant of the petitioner, my lord. Because the husband of the petitioner took loan from SBI rupees 11 lakhs, my lord.
I'll do you.
And the SBI wrote to the department that
Who is respond number 8 and 9?
8 is the second wife and 9 is the bank. 9 is the bank that.
Who is appearing? None. We posted for admission. In view of this. Huh? Taking into account the office note dated 21/6, the order of the Lozima Court dated 21/6/2023. The service upon the respondent numbers 8 and 9 are complete. As such, let the matter be listed for admission on 19/9/2023, 19/7/2023.
45.
Lordship, there is the order dated 21/4/23.
As per the earlier order, Lordship, I have received the instructions, Lordship.
Last paragraph of
Lordship may kindly
Was
peruse.
put under suspension by the order dated pending trial. However, there is no department proceeding initiated. In the meantime, on the basis of the order to ask the respondent to verify with the further commitment. We will supplementary that the principal secretary to government after make the Yes, what is your instruction? So subsistence allowance he will be getting.
Lordship.
And as regards the other one, he would not be entitled to for pensionary purpose, that period.
Yes,
Why?
not eligible for promotion to the next
No,
higher
I'm not on promotion. First pension.
pension.
Have you retired?
No, my lord.
No, he is not
Yes,
retired.
time. So
In this
have you
regard,
received the subsistence allowance?
50%. They should be after 3 months, 75%. They paid me 50%.
No, that they have already done it. So
it is-
you will
it
get
is-
the
it is,
other amount.
dated
So no issue about
24/5/23, Lordship, that order.
So we will do one thing. We will consider the other aspects
Might.
on the next date.
Might.
Heard Mr. M. Nath, the learned senior counsel, assisted by so and so, and Mr. D. Bora, the learned counsel, appearing on behalf of the Health and Family Welfare Department of the government of Assam. The learned counsel for the Health and Family Welfare Department submits that the Joint Secretary to the Government of Assam Health and Family Welfare Department have passed a speaking order holding inter alia that the petitioner would be entitled to draw enhancement of subsistence allowance at the rate of 75% of the last basic pay plus other allowance as admissible with effect from 2/8/2006 to the previous date of joining after reinstatement as admissible under rule in terms with FR 53 Roman 2 53 bracket 1 bracket Roman 2 bracket A of the FR and SR, subject to the production of a certificate that he was not engaged in any other employment, business, profession, or vocation. So taking into account the above, this court therefore directs the petitioner. This court, taking into above, the learned counsel appearing on behalf of the senior counsel appearing on behalf of the petitioner submits that the petitioner shall do the needful in terms with for needful to submit the certificate. Liberty is given to the petitioner to submit the said certificate, and upon submission of the said certificate, the subsistence allowance.
They already have given me 50%. So that
They have only given 50%. Then why do you need the
There's no
production of
requirement
the
for certificate
certificate?
now.
No, Lordship, this order is 24th May 23, Lordship. There it is. Therefore, the Government Family Welfare Department is pleased to allow Topan Hazarika. That means it is they will give after filing the certificate.
Understood. Madam, the petitioner have already received 50%.
50%. Now it is
50% you have given
75%.
because of the certificate. With the certificate, you have already given. He wants an additional 25%, which you have allowed.
In that case, I will file a detailed affidavit, Lordship, after receiving the Paraguay's comments, Lordship.
Okay. So and so appears on behalf of the Health and Family Welfare Department and submits that the petition that the Health and Family Welfare Department would like to file a detailed affidavit in that regard. During the course of the hearing, reference was made to a speaking order dated 24/5/2023, issued by the Joint Secretary to the Government of Assam Health and Family Welfare Department, whereby the petitioner was allowed to draw enhancement of subsistence allowance at the rate of 75% of the last paid drawn, plus other allowances as admissible with effect from 2/8/2006 to the previous date of joining after reinstatement. Taking into account the said stand, taking into account the respondent's stand, let the matter be listed again on 9th of August 2023, on which the Health and Family Welfare Department should file the affidavit without fail by 7th of August 2023. In the meantime, in view of the order dated 24/5/2023, the respondent authorities shall take appropriate steps for releasing the enhanced subsistence allowance to the petitioner. The state documents dated, the state speaking order dated 24th of May 2023 is kept on record and marked with the letter X.
Can I get a copy of this order?
Oh, you take it. Give it.
From her, my lord.
Yes, I'll
Give it to.
I'll supply.
Obliged.
46.
Yes, why the matter has come?
Non-payment of the area salary of the
Why the matter has come today? Orders here is it?
Yes, sir.
Orders here. Office notice नहीं any order you want me to do. No. You have mentioned the matter. The petitioner has not received salary from yes, any instruction?
My lord, as per my instruction, my lord, the petitioner are illegal teacher and subsequently she was
accommodated,
my lord. So, my lord, I need some time to file
affidavit,
my lord. So that I
Mr.
can
Heard, Mr. L. Mohan, the learned counsel appearing on behalf of the petitioner. Mr. B. Talukder appears on behalf of the Elementary Education Department. And Mr. The case of the petitioner, the respondent, the counsel for the Elementary Education Department submits that he requires some time for filing an affidavit, taking into account that the stand of the respondent authorities is that the petitioner's appointment was an illegal teacher and subsequently was accommodated pursuant to the cabinet decision dated 7/10/2021. 20. List the matter again on 11th of August 2023. In the meantime, the affidavit be filed by 8th of August 2023 without fail.
47.
What? Service not complete. Service not complete. What is the matter, madam?
Lordship, they want some area incremental benefits, Your Lordship. Earlier, they were appointed by the Director of Elementary Education. Lord. Then the school was amalgamated. So now they are under the Director of Secondary Education. So we have written a letter to the Director of Elementary Education asking for whether they are entitled to the area incremental benefits or not.
Why 5, 6, and 7? Who are those? Headmaster.
Yes, sir.
These things, what will the headmaster do? Indeed. Unless that is why your cases don't happen today. Amount is to be paid. It's response number 3.
There is only respondent number 3, Your Lordship, headmaster.
5, 6, and 7. Yeah. Italy. You have not taken steps against respond number the headmaster.
We have here.
Registered post you have taken, not usual. Okay. Yes, well, madam, what is your stand?
Lordship, we have written to the Director of Elementary Education.
By the?
Director of Secondary Education has written to the Director of Elementary Education whether they are entitled to the incremental benefits or not, area incremental benefits.
So, Director of Elementary Education has to be made party.
Lordship. Because they were appointed by the Director of Elementary Education. Initial appointment was.
You do one thing. Nowadays, this system has changed. I can't make you a party earlier as I was making. Okay. Your name?
DJ Bora.
DJ Bora, the Learned Counsel, appearing on behalf of the petitioner. Ms. D. Musari, the Learned Counsel, appears on behalf of the respondent number 1 and 2. It has been submitted that the Director of Secondary Education have written a letter to the Director of Elementary Education for the purpose of
Whether they are entitled to the incremental benefits.
as to whether the petitioners would be entitled to the incremental benefit as sought for.
From
In terms with the order dated 29/6/2019 issued by the Commissioner and Secretary to the Government of Assam Elementary Education Department. However, it's seen from the records that the respondent number 3, that the Director of Elementary Education is not a party of in the instant proceedings. Taking into account the power. Now, taking into account that the presence of the Director of Elementary Education would be necessary, this court therefore impleads the Director of Elementary Education as a respondent, as respondent number 4 to the having his office at
Director Lordship, it is Kahilipara.
At Kahilipara, Guwahati,
9
78109
009
019 as the respondent number 4 to the instant proceeding. The petitioner is directed to file an amended cause title. Amended cause title of the memo of parties. For which the registry shall upon filing of the amended cause title, amended memo of parties, shall insert the name in the petition as well as also in the CIS. Let the matter be further listed again on 14th of August 2023, on which date Ms. D. Musairi, representing the respondent numbers 1, 2, and 4, newly impleaded respondent number 4, shall obtain necessary instructions.
48.
Yes, Mr. Mandal.
This is regarding non-payment of pension of the petitioner with effect from 27/6/2018. Now, last occasion, your lordship was pleased to direct the other side, SP Chaudhary, to bring in instruction.
Who is he?
SP Chaudhary.
SP Chaudhary?
Huh?
CGC. Oh, there is no CGC. No. Why does this matter come up for orders today?
Most probably respond number 7 has not yet been served.
Okay. It reveals from the office note dated 17/6/2023 that steps where notice was only issued by registered post on 17/6/2023. Await service report.